2 3 ಸಲ ಬಂದಿಲ್ಲ ನೀವು. At least. What of sir? What of sir?
Next week.
Adjournment, number 1, page number 1, serial number 1 to 4, page number 2, serial number 5 to 9, page number 3, serial number 10 to 12, page number 4, serial number 13 to 15.
Not today. Today, how can that? You argue this, let us see what is that connected material. Yes.
Page number 5, serial number 16 to 20. Page number 6, serial number 21 to 26.
Yes. 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 At the request of council for the applied, leave this matter of 2 weeks.
Page number 7, serial number 27 to 33. Page number 8, serial number 34 to 37. Page number 9, serial number 38 to 44. Page number 10, serial number 45 to 52.
Yes. the request of counsel for the petitioner, leave this matter up to 2 weeks.
Page number 11, serial number 53 to 59.
Serial number 53, my lord. Last date of hearing, my lord, I submitted that this matter has been heard by Learned Coordinate bench, my lord. After looking into the file also, my lordship directed it to list it before the same bench. But again, it has been listed today here itself.
You are appearing for
This is
which
Shyam
matter?
Prasad, my lord.
53. Nodri, adi yaakre ಏನ್ರಿ order? What is that order we have passed last occasion?
After looking into the matter, my lord, it was furthering, it was listed for furthering, and it was a specially ordered matter. Again, after my lordship asked it to send it back to the same bench. But again, it has been listed here.
We list this matter next week and clear it.
Then the submissions of the senior counsel is also been recorded in the order sheet, my lord.
Application will not actually see that the dictation, I said that post before the appropriate bench and table. Yes, where is that matter has been treated as spotted?
My lord, may kindly look at the order dated 4/1/2021, my lord. The submissions is
4/1?
also been recorded. Entire submissions of the senior counsel has been recorded. 4/1/21.
4/1?
21, my lord.
Twenty-one.
Please, my lord. 4/1/21.
23, Mr.
21, my lord. 4/1/21, my lord.
4/1/21, it has been parted
Yes, my lord. Since then it is going on. Please, my lord.
from the. The Learned Counsel for. Is that? Allah, petitioner. Serial number 53 now.
Please, my lord. CRP number 322 of 2014, my lord. 322 of 2014.
Learned Counsel for the petitioner submits that this matter was parted before Justice B.M. Shyam Prasad
Please, my lord.
requested to post this matter before the same bench.
Petitioner's submissions was concluded, my lord. Arguments were concluded.
Office registry is directed to post this matter before Justice B.M. Shyam Prasad after obtaining necessary order from the Chief Justice. When do you want?
Any day next week, my lord.
Next week. Last time, last date,
Page number 11, serial number 53 to 59. Page number 12, serial number 60. One for petitioner, serial number 1 KP for appellant, Manjunath V.
Yes, Mr. If you are not interested, then we'll.
My lord, in this case, one KP and KP initial first ಬರ್ಬೇಕಾಯ್ತು. ಅದೊಂದು seal miss ಆಗಿದೆ. ಅದರಿಂದ ನನಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ. KP one, but filed column like that only. ಅದೊಂದೇ ಒಂದು miss ಆಗಿದೆ.
No, why this matter is posted?
Admission ಗೆ 2 weeks.
2017 matter, what has happened there, Mr.?
ಅದೇ I'll find out, my lord.
Whether
2 weeks.
suit is pending or.
ಅದೇ I'll find out, my lord. Because due to that I not received, my lord.
Learned Counsel for the petitioner appellant submits that requested week's time to expose this matter for admission on 31st. You verify what has happened to the suit.
Yes, my lord. KP, initial KP
Show the name of the counsel for the petitioner as
KP.
Bhuvan.
KP one.
KP Bhuvan.
KP.
Yes.
Yes, my lord.
Order serial number 2.
Instead of Bhuvan KP.
Yes.
Today, the senior petitioner.
Take steps, my lord.
Steps will be taken in respect of deceased R1.
I'll take steps.
Week's time is granted to the needful.
Serial number 3, Subramaniam.
Petitioner, my lord.
Yes.
My lord, we would pray for liberty to file a new writ petition, my lord. Hence, we are trying to change the prayer, my lord.
Government counsel for the petitioner has filed a memo seeking leave of this court to withdraw this writ petition with liberty to approach appropriate legal forum. The memo dated 18/8/2023 is taken on record. The above petition is dismissed as withdrawn with liberty to approach appropriate legal forum.
Serial number 4, Gopal Singh, petitioner.
For the petitioner, my lord, in this case. My lord, in this case, the relation between the petitioner and the respondent was that of a buyer and seller, my lord. Under an agreement that which was recorded as R1.
Non-filing of proof of
Yes, my lord, there was no
for
tenancy.
having paid that up-to-date rent.
My lord, there was never paid, the rent was never paid, there was no tenancy, my lord. The relationship was between a buyer and a seller, my lord, under an agreement that is marked as R1, my lord.
You are a respondent or a petitioner before the HS?
I'm the petitioner, my lord. In the lower court,
You
I
are
am
the
the respondent, my lord. This is a respondent's revision petition, my lord.
Respondent.
Yes, my lord.
You are denying that relationship.
Yes, my lord. The tenancy, the premises was given under a sale agreement, my lord.
What is that order passed by the trial court?
Eviction order has been passed, my lord.
That counsel for
Petitioner.
petitioner has submit that the petitioner has denied the relationship of owners and landlord and tenant, and they are not the tenant. Hence, he contended that there is no any proof of paying the rent. Submission of learned counsel for the petitioner is taken on record. The office objection is overruled. We expose this matter for
Much obliged.
Serial number 5, Vivekananda Estate for appellant.
Pending for the appellant.
non-filing of memo of justification with regarding to the note.
My lord, we have already stated in our appeal memo why we have not made them as parties. Kindly produce para number 7, page number 7.
Yes.
This is a case where one was the pleading application wherein I appeared for the honorable trial court and said no objection to the said application. But on this very same day, I came to know that.
What is that office objection? Note below the cost title. What is that note, Mr.?
Non-filing of memo in respondent number 10 has made party in this appeal who is not a party before the trial court.
Non-filing of memo in justification with regarding to the note below that cost title. What is that note you have put in before below the cost title? Not. Yeah, but short for relief. Now, whom you have not made as a party, Mr.
Lord, we have already made necessary parties. The office says, respondent number 10 is not a party in the trial court, but he's defendant number 43 in the trial court. My lord. It's clearly stated in the cost title.
Defendant number 43.
Yes.
The plaintiff is there. Where is that document to show that he is in the 43?
He was impleaded as a party. He was.
Actually, implead ಆದ ತಕ್ಷಣ amendment ಮಾಡಲ್ಲೇನ್ರಿ? Then you will become the party. 43 ಎಲ್ಲಿದೆ? ಬರೀ 3 ಜನ ತೋರಿಸ್ತಾ ಇದಾರೆ ಅಲ್ಲಿ.
Page number 37.
Huh?
Page number 37.
57.
37.
37. 32 members ಇದ್ದಾರೆ. 43 ಎಲ್ಲಿ ಬಂತು ಮತ್ತೆ?
Kindly page number 68, annexure G. That is the application filed by the plaintiff under order 39/1.
68.
The honorable court may be pleased to pass an ad interim injunction against the proposed defendant number 43 and not to disperse the award amount to any defendant or third parties. This particular application was allowed on the very same day.
while my pleading application was not adjudicated yet, it was still pending, my lord. This application has affected me and hence I am before this honorable court.
No. Pass an injunction order against the defendant number 43. You are not defendant number 43.
I am defendant number 35.
43. That injunction is start against 43.
Against the suit schedule properties, my lord, but my property is survey number 159/26 and 27, but that has not been included in the suit as suit schedule properties in the plaint.
No, your property
But-
is not included. You
But-
have not, there is no injunction against you. What is your grievance then? Injunction is not against you. Your property is not included. Then
Lord, it was an application for injunction against the respondent number 10, that is proposed defendant number 43, from dispersing the compensation amount to me. That has been allowed.
not to disperse the award amount to any defendant, third parties or any. What is that order passed by the trial court?
Again,
What is the intention?
page number 18.
Hmm.
Special land acquisition officer is extended by way of.
Page number?
18.
Hmm.
Dispersing the compensation amount to the parties in the suit and also to the opponents in IA number 1 and 1 of 2018.
You have filed an IA 1 of 2018.
They had filed and I said no objection. I was opponent number 3 in IA number 1 of 2018. So this order has.
IA is allowed.
IA was allowed subsequent on the next date of hearing, my lord.
You have been implicated now.
Yes,
Has a
as defendant number 35.
defendant number
35.
35.
Yes, it's clearly stated in the past title also.
Now that what is that office objection?
His objection is that other defendants have not been made parties.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇಲ್ಲ ಮತ್ತೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 1 to 34 and 36 ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
Defendant number 1 to 34 ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ?
The reason is that they are sailing along with me.
They are not contesting parties here. ಎಲ್ಲ ಹಾಕಿದಿರ ನೋಟ್ ಆ ತರ. Have you stated somewhere here that there is no relief sought against them? ಮತ್ತೆ ಅದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡ್ರಿ.
I'll do that.
Yes. Each time
Interim order.
without applying that office objection, you have obtained interim order. Yes. Therefore, 2019 office objection is not complied. Interim order is obtained. Who will comply office objections when interim order is there?
I'll do that.
Will not extend that interim order when you have not complied.
Lord, I'll
Yes.
do it in a
In
week's
which time is granted to comply that office objection. Interim order granted, if any, is extended till next date of hearing.
Number 6, number 6.
Non-compliance of office objection, D. Gangadhar. Yeah, office objection.
ಮೂರಿದೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಟು ಬಿ ಫೈಲ್ಡ್. ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಅಪೀಲ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್.
Also, yes, each time is granted to comply that office objection.
Number 8, N. Prem Kumar.
Three other supplement party now.
Number 8, N. Prem Kumar, appellant party.
In spite of granting sufficient opportunity for more than 5 times Office objection is not complied. None appear for petitioner. Fine. The appellant has not engaged any counsel. It appears appellant is not interested in prosecuting this appeal. Its appeal is dismissed for non-prosecution.
Serial number 9, Sangamesh RB for appellant.
I think I said it new or ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. For that appropriate bench. Sangamesh,
Serial number 9, Sangamesh RB for appellant.
also
Serial number 10, M. Srinivasa Babu for appellant.
President, take steps.
each time is granted to do the needful.
Serial number 11, Jayaraj PS for appellant.
Because I appear for the appellant in this matter.
Counsel submission with regarding that office objection.
Please, my lords.
Yes.
Lords, the office objection has raised that this appeal is not maintainable by
Yes.
virtue of the order passed. My lords, kindly see the prayer. I am seeking to set aside the order passed by the Honorable Trial Court in dismissing my miscellaneous petition, seeking to set aside the order that has been dismissed for non-prosecution. Therefore, this appeal is filed. My lords, and the only sole ground that my suit is my mispetition is dismissed on the ground of delay. Delay condonation agilla. On that reason, my entire miscellaneous petition has been dismissed.
No, miscellaneous petition is filed under which provision?
My lord, order 9 rule 13, I have sought to set aside the dismissal of the suit. And my
Under
lords,
Rule 13, if it is dismissed, then it is an appeal. In which provision you have filed an appeal?
order 43,
43? You are not sure that under which provision you are filing. Your all petition has been, strike down that this thing, and again you have rewritten.
I have written that. My lord.
What is that? Tell me now, which is the provision?
I will.
You
Kindly
don't know
pass
that
it
which is
over.
the provision?
Kindly pass it over. I will argue. I will make my submissions. my lords.
Yes, also
Please,
230.
please, my lords.
Number 12, MS Bhatt for appellant.
30, corrected. Yes. Pass title with regarding to that petitioner number 2 before the trial court not arraying as a party in this appeal. Why?
He is not interested. That's the reason I have made note of it. Page number 5.
Who is that petitioner number? What is that?
The both are negative, my lord. Both are negative. Now my petition is dismissed. P&S
You have filed a petition.
under P&S for a grant of profit under 278. That has been rejected by the client.
Now that you have filed a petition, why he has not been made as a party as a respondent?
I will respond for them.
Both has filed a petition. Huh?
Both petition are done. I was solely interested in getting the
Yes.
records may be called.
Yes. Submission of learned counsel for the petition appellant is accepted. Office objection is overruled. Office is directed to secure original records for the P&S court.
Serial number 13, Narayan MS for appellant.
Two, three lords. Fight call.
Writing service of notice to R4.
R4 he is residing in USA. ಅದು steps ಹೋಗಿದೆ.
Hmm.
Forum he is a brother of appellants only.
Yes, yesterday, why it
Day
was-
before yesterday it was there.
The amount has been already released in favor of the defendant number 1 and 2.
what is that matter?
That's not for partition, my lord. According to my information, my lord, Respondent number 5 and 6 have been released their amount.
No, suit for partition.
Yes, my lord.
What is that order you are challenging here? Who are you? You are a defendant or?
I am the plaintiff before the trial court. My lord.
Uh,
Filed a suit for partition.
Hmm.
There are item number 1 to 13 items, my lord.
Hmm.
Item number 5 to 13 have been acquired by the respondent number 8, my lord.
Hmm.
In the meantime, composition has been with the respondent number 8.
What is that order you are challenging?
Order is at page number 10, my lord.
Hmm.
I filed I number 8 on 39 rule 1 and 2. Not to disperse the amount to respondents 1 and respondents 1 to 3, my lord. Trial court has rejected my application.
Why?
Stating that there is no documentary proof. Still, it is not gone for the evidence stage, my lord.
Again, why? What is the reason here?
Reason, my lord, what the trial court and the Lord judge has passed is the document produced madilla.
In documents.
All the self-acquired properties and come into this was the conclusion just come before the trial court.
Now that amount is released.
Released 1. According to my information, my lord, 5 and 6 have been released, my lord. Avrdu matra. In 1 and 2,
You are appealing for
I am afraid to respond number 1 to 3.
then partition suit is there.
No, earlier partition suits filed by me, the defendant number 1. He filed a counterclaim, the present appellant. He claiming that there is already partition between the family members. The present suit is pending, OS 836 of 2015. It's still pending. He filed a counterclaim, there is already partition in para.
I think this property which has been acquired by that
No, these properties has been obtained by the defendant number 2 to get it.
I have not completed my question, Mr. Property is acquired by whom, Mr.
Defendant number 1 and 2 lordship.
our brothers brother and
Who has acquired that property, my Mr. Compensation, who is paying?
respondent number 8, man.
Yaar ಹೇಳ್ರಿ.
KDB. Sorry.
See, land which is acquired by the KDB is under the partition allotted to you.
Yes, Lord.
That's what they claiming, man. Other claim. But
Not earlier partition, it has been allotted to them.
it was not allotted. What the thing is, my lord, they are claiming on us. I am the second wife's children, man. Second wife has acquired the properties. Second wife and second wife brother acquired the properties.
Yes.
Your first wife children are claiming the partition against the second wife's property as well as brother's property.
Now that you are appearing for
Second wife's children.
Second wife, first wife children, lordship, a movement, lord, first wife children.
You are appearing for the which defendant?
Defendant number 1 to 3.
1 to 3.
Yes, lord.
You have not yet received that amount.
We have received the amount.
You have received that.
Received the amount. These are the self-acquired properties of the defendant number 1 and the gift deed obtained by the defendant number 2 from our father.
Anyhow, that now you have obtained that this thing. I will say that further releasing of the amount will be stayed.
A movement in page 17, lords. A movement,
Yes.
in page number 17.
Yes.
On perusal of the RTC photocopy, stated all the material placed on record.
Yes.
It is prima facie appears that the suit property item number 563 is standing in the name of defendant number 1. The photocopy is registered sale deed 18/11/22 disclose that defendant number 1 has purchased the suit property item number 6 that 3/2 in the erstwhile owner. The copy of the sale deed dated 1988 disclose that defendant number 1 has purchased the suit property item number 7. Survey number 40 P2 from the erstwhile owner. The photocopy registered sale deed dated 9/2/90, my lord. Disclose that this suit property item number 8 90/4 is purchased by
That you are saying that
the defendant number 2. Defendant number 2, lordship. Defendant number 2 purchase.
You are claiming that it is your self-acquired property.
Self-acquired property, and again, the father of the defendant number 2 has gifted the certain properties which has been included by the plaintiff. Other than father ಕೊಟ್ಟಿರೋ properties ಇದೆಲ್ಲ ಅವರು claim ಮಾಡ್ತಾರೆ. Further, my lordship, further. The item number survey number.
What is that amount?
Gifted 2004, which has.
What is that amount which is awarded by the land acquisition officer?
Not getting any document. The defend.
Get that? What is that amount? We'll see that. What is that other property? If they are, if you are successful, even you can claim that other property. We'll see that.
ನನಗೆ ಗಿಫ್ಟೆಡ್ ಆಗಿರೋದ್ರಲ್ಲೂ ಅದನ್ನು ಪ್ರಾಪರ್ಟಿ ಸೇರ್ಸ್ ನಮ್ಮ ತಂದೆಯಿಂದ ಬಂದಿರೋ
ಅವೆಲ್ಲ ಡಿಸೈಡ್ ಆಗ್ಬೇಕಲ್ಲ ನಿಮ್ದು ಅವ್ರದ್ದು ಸೆಲ್ಫ್ Tuesday you verify that what is that amount, total amount for acquisition. Yes, we'll see then how much it has to be. At least your portion can be not to release, other can be released. Why you have to stall all that releasing of the amount.
Axial partition, they already.
I will see that we do that Tuesday. I will
Yes.
hear you on Tuesday.
Yes.
You verify what is the total amount it is there for by acquisition. Yes.
Serial number
Use this matter on Tuesday.
Serial number 14, Bharat K for appellant.
Yes.
Sanjay,
Pastor. Pastor, anytime it will reach, you can come. Yes.
serial number 15, Siddhananda P for appellant, KP Jaisimha.
Appellant's list.
Yes.
On it, my lordship. I had filed an affidavit. Day before yesterday, matter was listed this morning. For office objections and for filing. We had offered to serve the copy, they did not receive the copy. Court had directed to file an affidavit, we have filed an affidavit.
Yes.
And in fact, we had also sent it on through speed post that has been delivered.
He himself is present. before-
Please, my lord.
I received through post, my lordship.
Why you have not received that?
Day before yesterday.
My lordship. Council is filed modification of order before the trial court. So I confused in the copies. So because of
Whatever the copy which is served, you can receive it by putting a signature, that's all. Or if you still want to confirm, you can, clarify that whether the same copy is served or not, because rule is provided. Once council is represented, High Court rules provided that copy can be served to that council.
Council.
Even are their council's clerk also. Now, what is that matter?
My lord, defendants
what
appeal.
of time to file objection and occurrence.
Yes, Mr. He wants time. What is that
My
urgency?
lord, taking and having an advantage of the interim order placement, they have interfered with my property. There are two properties. One is suit schedule property and the other is return statement schedule property. Under the guise of obtaining an order for suit
What is
schedule
that? What
property.
is the suit for?
Suit for injunction, permanent injunction.
Yes. You are a plaintiff or a defendant.
I am defendant.
What is that interim order passed by the trial court?
Your lordships could see at annexure A at page 20, page 20. The findings, please, not at the
Defendant
reasons.
and their agent, salesman hereby restrained from interfering with
With the suit schedule property. What has happened, please, not suit schedule property is a fictional property. That property does not exist. They have filed a suit on the basis of a sale deed executed in favor of the plaintiff in the year 2021. In the year 20, that is the first sale deed, first title deed, it has been obtained. On the basis of that sale
There is
deed,
an injunction in respect of the suit scheduled
suit
property.
schedule property.
What is that document to show that you are in the position?
Please, not suit scheduled property does not exist. I am in.
No, if it is not exist, then
I
interim order.
am in property number, site bearing number 57, that is return statement schedule property had made it very clear under the guise of this.
You see, you are saying that you have any different property.
Please.
That is not a suit scheduled property.
Please.
Injunction is in respect of the suit scheduled property. Why are worried?
But the thing is, please, not the court has arrived at a conclusion that there is identity of the property is in question.
Suppose your property is B.
Please.
He has taken injunction to A. What is your grievance then?
Under that guise of that order, please, not he has interfered with my property and he has demolished my
You
property.
give a complaint.
That complaint is
See,
also, please.
suppose person who has taken injunction to that Vidhan Sauda, he tried to interfere into that High Court.
Understand.
That is for the duties to advocate how to protect that.
I understand.
How can the court interfere if it is not your property?
I understand, please, not. But what has happened, please, not. Your lordships may kindly take to the list of documents which I have produced, please, not. At page.
No, that prima facie you are saying that that is not your property where injunction is granted.
Please, not the court ought to have, after having come to the conclusion that the identity of the property is in question, that is matter of trial, the court should not have granted an injunction which they have taken advantage of.
No. They can mislead, they can use the police, it is different. Now the thing is, injunction is granted in favor of the suit scheduled property. Scheduled is mentioned.
Please, my lord.
That scheduled is not your property.
That schedule is not my property, but
You explain that person who has interfering or give the police complaint.
the police
See-
complaint has been registered, please, not. That has been registered.
See,
What has happened?
if persons, then you file in a suit for injunction in respect of your property. Somebody.
I have already filed an application in the same suit for injunction against the
Okay, yeah.
plaintiff. Under 39(1)(a), I have filed it, please.
The thing is, see, how can you file you for an injunction because that is not the property which suit schedule property.
In respect of my property, I have filed an application because it is an incidental concept.
New property, you have to file in a separate suit.
39(1)(a) provides for our defendant to file an application.
File an application for suit schedule property, not that other property which is not in a suit schedule property. Then file in one suit. Everybody can file an injunction paying that other suits also without paying the court fee. But see, defendant can also file in respect of the suit schedule property. But you are yourself saying that it is in a different suit schedule property.
What the trial court should have appreciated is not when I have
I
made a
can understand your problem.
specific
He
case.
has taken an injunction in respect of the suit schedule property, whether that property is existing or not, but he has tried to interfere your property. But if it is not an injunction against that property, you have to protect it. How, what we can do it, Mr. See, now you can show that you are in the possession of B property, but injunction is against the A property. What this court can do it? Tell me that. I can grant an injunction in favor of your property, which is not in a dispute.
Please, my lord, all that I am seeking before this honorable court is not the court, the trial court had to appreciate. Please, my lord, your lordship may kindly take to the order passed by the trial court. Please, not at page 30. Page 30.
Yes. What is that?
Starts from 11. Please, my lord, page 28.
Yes.
The reasoning starts from there. The plaintiff claims to have acquired the suit schedule property by sale deed dated 25/10/2021.
Yes.
The sale deed is executed and on perusal said document is found that Rupesh Murthy, son of G. Narasimha Murthy, has sold the scheduled property in favor of plaintiff, and the scheduled property mentioned in the plain tallies with the schedule mentioned in the sale deed. Further, Kata extract and tax paid receipts are all. Tax paid receipts along with the encumbrance certificate reflect that the plaintiff has purchased the property from defendant and he has been paying taxes consequent to the sale in his favor. Further, Bescom has sanctioned power supply to the plaintiff in respect of property bearing number 18/6/6/6. The plaintiff has also produced complaint addressed to the jurisdiction police on 6/6/22 against the present defendant for trespassing the suit schedule property. The case of the defendants is that the plaintiffs have not acquired the suit schedule property and the plaintiffs has no right over the same. The claim of the defendants is with respect to property wherein site number 57 found in the portion of land bearing survey number 18/6A and converted at survey number 18/6. Though the defendants have disputed the existence of property, but they have not undertaken to demonstrate their right over the suit schedule property described in the schedule. The plaintiff. The existence or non-existence of the scheduled property and the entitlement of the plaintiff for the relief sought in the respect of suit scheduled property is the subject matter of the trial. The defendants, though, have contended that the plaintiff has attempted to show the written statement property as suit scheduled property, but no document so far have been produced by the defendants to doubt the case of the plaintiff and existence of the property claimed by the plaintiff. The defendants have relied on the document which pertain to site number 57 and not with respect to site number 6 in survey number 18/6. The documents produced by the defendants, including Kata extract, Kata certificate, and tax paid receipt, all pertain to site number 57. Similarly, the encumbrance certificate also pertains to site number 57 in new site number 18/6. The description of the boundaries pleaded by the defendants in the written statement are completely different from the description of suit scheduled property. The defendants have produced the complaint filed by the third defendant against the plaintiff and one Narasimha with respect to FIR number so and so. The the complaint is dated 4/11/2020, wherein defendants have complained against the act of trespass committed by the present plaintiff, and the defendants have also produced Xerox copy of the statement made by the present plaintiff in pursuance to the complaint made by the defendant, wherein plaintiff has specifically stated that the site purchased by the plaintiff is not concerned with the site owned by defendant and had undertaken before the police officer not to cause obstruction to the defendant. Though the said document is produced by the defendant, but the statement therein clearly indicates that the suit scheduled property and the written state scheduled property are entirely different, and in this regard, plaintiff has undertaken not to cause any obstruction to the defendant's property. Please, my lord, your lordship may now kindly take to page number.
What I have expressed, same thing.
I understand, please. 81, page number 81, the photographs after subsequent to the interim order being passed, how they have damaged the property. 57, the property is clearly identified as 57. please note.
Now file a contempt, they are violating that order. They have undertaken that they will not interfere your property. You can't file a contempt there.
Contempt, please note, if there is a specific order, please note, I can file a contempt. That is a statement given before the police.
No.
That has been considered by the trial court.
No, now that injunction is granted in A scheduled property.
Please,
If
note.
he is doing in that B, is it not violation? Taking that court order advantage and he is doing that. See, that is the remedy. Here, again, same thing. Court has granted an injunction to A, you are claiming B, there is no dispute. Trial court has given, what order can be passed? Even taking an injunction to the A and he is disturbing B, either you have to file in a contempt or you have to file in a separate suit for protecting your property. That is the remedy. I don't think we can pass, even if I pass status quo also, it is only in respect of A. You are claiming B. You taking use of that A, he is doing in B, then you know that what is the remedy? Either contempt or you have to file in a separate suit. I think it is a clear finding by the court. And you have also admitted, you are not disputing.
We are not disputing and we have clearly said that this is a fictional property. That property does not exist.
That's what.
But the court has come to a conclusion, we have not produced any documents to show that suit schedule property is a fictional. If the property is fictional, please note all.
That will be decided in the trial. Now, if your case is that what the property is claiming under the suit is the same properties of your, then you have a case. You are yourself as making a submission and return statement said that my properties is B.
Please note.
He has trying for an A, that property is not existing. That now that he has taken an injunction in respect of the non-existing property. But if you trying to that B, then you can.
Please note, all that, please note, the trial court having come to the conclusion, prima facie, the plaintiffs have failed to show that the identity of the property, distinct identity of the property, independent identity of the property, the court below could not have proceeded and granted an injunction, which has caused the confusion right now.
No. That's, you can't say that. That is different thing. See, now it is very clear how it will affect your right. See, if a person who has taken an injunction and taking that benefit and being going to that other village.
Under the guise of that, he is interfering with my property, which is separate and distinct.
That means there is no order in his favor regarding your property. If somebody is coming to your property, you know what you have to do. Either you find out whether you can file in a contempt or you have to file in a separate suit for injunction.
In fact, your lordship may kindly appreciate how they have.
No, I know that what are happening in that Bangalore, how they are doing, but in the law itself, what we can do it, this is only. Now that you are the council, you have to advise your party.
Overnight, please not, he generates tax paid receipts from 2008 to 21 in his name. When he has purchased the property in 2021, from 2008, he generates the tax paid receipts in his name and he has produced.
Everything is possible here. Now that only that your claimant, he is also claiming that there is no injunction in respect of your property. There is no injunction because sometime they will show that some survey number, but boundary is related to that other side, then it will prevail. But this is the case, is boundary is also not.
Two distinct, separate properties.
You know that what you want to do. Notice.
He is present, please.
Then I will dispose of. Or you will pending, you verify what is that remedy you have to be.
We kindly be taken upon. Wednesday, please.
Yes, release this matter next week. Yes. No, Mr. That is his case. He has to make out any case. Yes.
60 case Bhimaya for appellant T. Prabhakar.
Appellant in this case.
What is that?
That office objection is with regard to the appellant number one is a Samaja and appellant number two, while filing the suit, the respondent has made the administrative manager as a party. So he is not a necessary party, whereas the appellant number one Samaja is represented by the secretary of Samaja. That is what I stated in the Roman 3.
Now plaintiff for a defendant.
I am for the defendant.
Defendant.
Yes. Dependent number two is not a necessary party. That is what I stated.
It is.
In the para 3, Roman 3, I stated the appellant number 2 is only an employee of the appellant number 1, Samaj, and he is not a necessary party. Since the respondent herein, while filing the suit, made the appellant hearing as party, in this appeal also, he has been arraigned as the appellant number 2.
Party ಮಾಡಿದ್ದು. What is that office objection?
ಅಲ್ಲ ನಾವು ಅವರು ಇದರಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅಂತ.
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ಯಾಕಂದ್ರೆ in trial court also we are not filed because
Then you won't make it party. If he is not in a party, if he has not given wakalat,
Yes.
you can't represent him.
No, I am not representing.
No, you,
Since they made a party before the suit.
no, then either you have to make him as a respondent, not make as an appellant. Once he is an appellant, you have to represent. Otherwise, you see whatever the content.
That is what I stated, my lord.
You delete him that.
I will delete. I may be permitted to delete.
Delete
That
him.
is- Yes.
If he still is required,
Yes.
you make him a respondent, or you say that he
Delete ಅಂದ್ರೆ why ನಾನು ಏನಕ್ಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ since before the trial court they made as party. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ನಾನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆಫೀಸ್ will raise objection.
rise ಅಂತಂದ್ರೆ you can say
Yes.
there is no relief or he is not an interested party, therefore I have not made an ಅಂತ ಅಂದ್ರೆ office objection ಮಾಡ್ತಾರೆ, ನಾವು overrule ಮಾಡ್ತೀವಿ. But once he is an appellant, then somebody has to file a wakalat. He cannot be, because without his permission you have filed an appeal. Tomorrow if it goes against you, he may say that I have not given wakalat. Who has filed?
No, you lost me kindly appreciate. Before the trial court he has been placed expert because
That is true, Mr.
Yes.
Today, if any benefit is goes, as an appellant, it will goes to him. If any reverse order, it will also goes to him because he is in a party.
I will file a necessary memo and get it
Yes.
deleted, my lord. In the meanwhile, matter, my lord. I
No, pass over, you delete.
my lord,
Yes. 230. Pass over, Mr.
2:30 in ಬೇರೆ ಕಡೆ 2 minute ಬೇರೆ public court.
Monday.
I will argue the matter, my lord.
No, first
In the meanwhile, I'll file a memo.
Now if he closes, then I will make a submission.
I'll make
Lord,
my
I am
submission.
the plaintiff. I have made the necessary parties who try to interfere with my peaceful possession. Second defendant was the instrumental in interfering with my peaceful possession. I made him as a second defendant. Now, my friend cannot say that he is not a necessary. If he is not a necessary party, he takes the risk. I have no objection.
Why that, Mr. Counsel,
Yes.
you are highlighting all these things?
No,
You are
no.
in a council, you have to keep quiet. Tomorrow he succeed,
Yes.
injunction against that second respondent will continue. He cannot, that she has to, he don't want to make him as an appellant. Then you delete it.
No, I will file a necessary. Then I will file wakalat, my lord. In the meanwhile, I will file a wakalat.
That is better.
Meanwhile, in the
When
meanwhile,
that order is against him also, better you file an
Meanwhile, matter may be heard, my lord, today.
Tuesday. You do it, otherwise
Not
unless.
Tuesday, Wednesday.
Not
Tuesday,
Tuesday.
I have got 2 minutes.
No, that is the case, my lord. Let
Wednesday.
them maintain status quo, my lord.
No.
with regard to that. Let them maintain status quo.
My lord,
You will have it on Tuesday. First you comply that of subjection. Otherwise,
The meanwhile, let them maintain
no,
status.
there cannot be any order, Mr. He is in a party.
No, no. Let there be, my
No,
lord.
it has come for objections.
If I pass an order, in interim order, he will be shown as an appellant without wakalat. Interim order cost list ಏನಾಯ್ತು ಅದನ್ನೇ ನಾವು ಕೂಡ interim order has to be passed. That will be interim order will be signed by me. My order is that person who is not in a party is also a beneficiary of that order. Tuesday.
No, my lord, not Tuesday, Wednesday. Only
Wednesday.
1 day accommodation.
Yes, Wednesday.
Wednesday.
It is then requesting my learned friend. Let them
ಇಲ್ಲ,
not.
Monday ನೇ ಹಾಕೊಳ್ಳಿ. I have no objection either Monday or Wednesday.
Monday.
Only Tuesday is
Monday.
inconvenient. Yes.
Monday. Yes.
Monday is.
You file an wakalat for him
Yes, yes.
better on Monday.
Serial number 17, R. Kumar for appellant, government advocate, case Bhimaya.
Yes, Mr.
But it's clear that my name is showing the past like title, but I have not issued.
Not at,
No.
not at served copy. my lord.
We have directed to take notice.
ಅಲ್ಲ,
Next week,
ನನಗೆ ಅದೇ copy ಏನು ಕೊಡ್ಲಿಲ್ಲ ಇದು.
Kindly have it next week. Meanwhile, complete the officer
You
section.
serve a copy to him
Including,
also.
including serving copy.
Yes. The net council for appellant waste weeks time to comply that of subjection.
6 stars.
Yes. Read this matter on 7th. In the meantime, you serve a copy to.
What?
Serial number 18, Harish Mandariti for appellant.
Your Lordship, I am
Awaiting service
What
of notice.
what is-
to-
memo I am producing, Your Lordship, for service of handsome ones to the party itself. I have served, Your Lordship, yesterday. Yesterday.
Within 5 days to which case will be posted. When it is served,
Yesterday, Your Lordship.
Then there is a 5 days time is there.
So day after yesterday, I got the copy.
See, through that advocate duly instructed through someone authorized by law of act this case within 5 days to which case may be posted hearing. Yesterday antandre, then we will have it on Tuesday. 5 days has to complete. Yes. Reach this matter on Tuesday.
Memo will be taken on that.
File it in that office. Yes.
Number 90, Revana Ballari for appellant.
Not press button.
Yes, madam.
Not press button. Subjection to complaint.
Not press madam, office objection.
Yes. Not press button. Official credit.
Yeah, there is no that. There is no any that IA which has been shown in that office objection. You want to comply that office objection? Yes. Learned counsel for the petitioner pays 2 weeks time to comply that office objection.
Number 20, Girish V. Balagare for petitioner P. Nataraju.
First instance. And I am filing a memo, my lord, reporting complaints of order dated 27/7/20
You are appearing for whom?
for petitioner.
Have you deposited that 50%?
Yes, ma'am. Yes.
Where?
Before the trial court.
Acknowledgement having produced.
And filing the memo today, my lord, I have filed NOC Wakalat on 21st August.
What's your name?
SM Shivabi Raya.
Now that Girish is not there. You are given no objection. Yes. Office is directed to delete the name of Girish V. Baldare for the petitioner. Show the name of so and so.
SM Shivabi Raya.
Yes. You file it in that office.
Yes, ma'am.
Yes. Learned counsel for petitioner submits that he has deposited that 50% of that maintenance amount as per the order dated 27/7/2023 before the family court. To that effect, he will produce that acknowledgement before the registry.
Number 21.
My lord, I appear for the petitioner in this, please, my lord.
Yes.
My lord, I complied with the office objections, my lord. The objection raised was not the full cost title was not disclosed in the application condoning delay, my lord. I
Yes.
complied.
Have you complied?
Yes, my lord.
You have not complied, mister. You have not made full cost title in
My
IA.
lord, if the matter is kindly listed on 30th, before that I will comply, please, my lord.
Yes. Which type is content to comply that of subjects?
My lord, kindly a date may be fixed, my lord.
No, we have taken time. You have not complied. If there is an urgency. Yes.
Obliged, my lord. There is urgency, my lord. Recovery petition has already been instituted, my lord.
Why you have not complied that of subjects? Yes. Next week.
Obliged.
Number 22, Varun RR for petitioner P. N. Ravi.
It's a delay of 120 days. Usually, petitioner had because it's honorable court.
No, where is P.N. Harish? Yes. Have they filed any objection for IA? Yes. There is a delay of 120 days in filing a petition.
But usually, it is actually 45 days. Initially, I had allowed this honorable court by filing a petition. It's 25 days in filing in the writ petition. So it is 45 days actually.
No, that filing this writ petition is also one of the ground to condoning the delay.
Please.
Delay time will not be expanded.
Please.
Yes. That is the one of the reason for condoning.
Please.
Delay of 120 days in filing a petition. Peruse that affidavit filed along with that application for the reason stated in that affidavit. Delay of 120 days in filing a petition is condoned. IA 1 of 2020 is allowed. Post this matter for admission. Yes.
Next week. Because the executing court has dismissed the application. Execution petition on the basis of memo.
Tuesday. Post this matter for admission Tuesday.
Serial number 23, Navish Patil for petitioner, SN Bhatt.
Yes.
Delay of 114 days, my lord. They filed their objections also. And it may be condoned and matter may be posted for admission.
Yes, Mr. What is this petition for?
Petition for declaration.
What is
Challenging
that?
the order passed by.
What is that order you are
My
challenging?
lord, the order under challenge, my lord, is an order that has been passed under section 11 of the CPC. Earlier, my lord, it's a suit for partition, my lord. Suit for partition. Earlier, my lord, respondent number 8, that is Krishnamurthy, my lord, had filed a suit. That is one of the brothers. Stating that, my lord, this is an ancestral property, and in which, my lord, all other brothers filed the written statement.
What is that section 11 petition?
Please, my lord, it is on the ground of res judicata. Now, my lord, what happened? The earlier suit, my lord, was contested by all the brothers.
No, that res judicata. It is a mixed question of law and facts. It has to be decided by trial.
My lord, but the reason is, my lord, the earlier suit was contested by all the brothers, and my lord, they
Is
filed
it not
written
available
statement.
under Order 7 Rule 11?
No, this is not under Order 7 Rule 11, my lord.
No, that dismissal of the suit on the ground of.
My lord, that earlier suit, fully it was contested, my lord, the suit came to be dismissed. Now, my lord, another brother filed same suit for partition, who had earlier contended that it's not an ancestral property, it's a self-acquired property.
No, that on that ground suit can be dismissed for threshold.
My lord, only in respect of respond number 8. Our prayer is only in so far as respond number 8, the suit may be dismissed. Because, my lord, earlier he had filed a suit and it is already been dismissed. Now, all contrary, please, my lord, I'll show it to your lordship, my lord.
No, that is it such an application can be considered.
Please, please.
What about that Order 7 Rule 11?
Lord, we have filed an application under Order 7 Rule 11 also, but still it is pending consideration before the trial.
I think that is the correct remedy. That is the only remedy for threshold dismissal of the suit. There is no other provision to threshold. See, this may be the ground for trial.
Please.
But can it be dismissed?
Lord, only in so far as respond number 8, because he was the plaintiff in the earlier suit.
No, that you can say non-joinder, misjoinder of parties and all.
Illi brothers ಎಲ್ಲರೂ party ಮಾಡಲೇಬೇಕಾಗಿ.
No,
In the earlier suit
show
also
me-
we were party.
Show me any judgment.
Please,
It can be dismissed as threshold under under section 11.
please. Your lordship may have it next week for admission, my lord. I will also.
The judgment is.
And I
Because
also
I
filed
think
a memo along with
That
documents
may
of
be
the
the
earlier
case
suit.
for rejection of the plaintiff.
Please. I
I
follow.
don't think it's you just
I'll
give
examine.
me that first mental liberty,
Please,
then we will see the merit.
I'll examine.
Yes.
Your
We'll condone
delay
the
may be-
delay.
Delay may be controlled.
Yes. There is a delay of 114 days in filing in a petition. IA 1 of 2023 is filed for condonation of delay. There is that affidavit. For the reason stated in that accompanying affidavit, delay of 114 days in filing in a petition is condoned. IA 1 of 2023 is allowed. Post this matter for admission next week.
Number 54, R. Sadadev for petitioner.
22 days delay is there, my lordship.
Notice.
Serial number 25, Arjun. Serial number 26, Manmohan PN for appellant.
Yes. What is that recalling? Why it is dismissed?
Valuation slip filed before the trial court note had to be placed. And
No.
not with regard to peculiar.
What is that order at 12/6/23?
Oh. Well, it's a conditional order. By the time we got the,
Condition order passed by the registry.
what has happened is not LAC case. But it was clubbed with not several other LAC cases, included my other case.
No, that I have seen this provision. Register can pass condition order for dismissal.
There is some regulation that has been made.
No, have you
I
verified
have
that?
not verified.
See that I have also not seen, but whether that can be done in, because
Amendment to the.
the amendment agide. Go through this, whether
He can
Such a
pass
po-
an order.
such a power is there. or he has to refer to the court for dismissal. Petition stand dismissed in view of Rule 14(2).
What time of 4 weeks shall be available to comply with within 2 weeks expiry, the matter will come. The 4 weeks shall be listed with the registrar of this. Whatever chief justice. Participating in the papers of the advocate, presenting the papers shall get appear with the registrar. How to pass preventory order dismissing the petition, appeal.
Then he has the power.
He has,
Yes.
he has no power to recall.
Recall, he has no power.
He has no-
Yes. Yes, now you have completed that office objection.
Objections not with respect to few of them have complied, but some not with respect to valuation. That office objection not be obtained, not the certified copy from the trial court. But this is a miscellaneous petition to recall an order, not push the trial court. Therefore, not by filing miscellaneous before the trial court, but there will be no separate valuation as such.
No, but what is that valuation in the suit? That is
So
jurisdiction
it is
purpose.
an LAC case. Not in an LAC case, with this not by deep, by not it was clubbed with other matters. Only this matter
No,
was.
what is that award passed by that land acquisition officer?
But award was passed in 2008.
What is that amount?
That is amount is not 1,992 per square meter.
What is that your property?
Not I have challenged not in LAC 123 of 2010. Seeking management at the rate of 5,000 not per square feet.
No. Court fee has to be paid.
No, court fee will come not only when I file an MFA. In respect of an order passed in LAC, there not I am liable to pay court fee.
No.
But here,
No, valuation. What is that award passed by that land acquisition officer? It is 1,000.
the reason is this. There my LAC is dismissed for non-prosecution. I file a miscellaneous petition to recall that order. Adike nanu court fees katbekagilla.
No, it is not for the court fee. You are not under. For a jurisdiction purpose. See, for High Court also,
Yes, 15 lakhs.
15 lakhs and division
Very well,
bench.
very
Therefore, we want to see what is that property.
That will not come not in this matter. Reason being, valuation will be with reference to the miscellaneous petition, not with reference to LAC.
No. Jurisdiction will be that trial court, this thing. You tell me that what is that value of that property? And that a land acquisition officer has been passed an award of 1,000.
Then not it will come beyond 15 lakhs.
Then that's why
It will come
court,
beyond 15 lakhs.
then
No.
it has to go before the division bench.
Largely, the only thing is not distinction is only this, my submission is. When it comes to LAC, not that valuation will come. But when it comes to not miscellaneous petition.
No, we are not deciding that. See, miscellaneous petition, you are deciding. See, ultimately, value will be the jurisdiction of that court. Now, what are maybe the purpose? See, even the division bench is also can be decided regarding the dismissal of the miscellaneous petition.
No difficulty with that. But
Yes.
what I'm trying to say is, that's it, not, the valuation will not come for the purpose of miscellaneous petition is what I'm saying, because I am before the laws. As against order of dismissal of a miscellaneous petition.
No, that nothing but that dismissal of that suit itself. Degree. If miscellaneous petition is confirmed, what is that LAC court has passed as then confirmed, is it not?
LAC did not pass order on merits. Pass an order for default. Therefore, what is sought to be recalled by way of miscellaneous petition is only the order of dismissal. It's not an order of merits. Therefore, that distinction is there. Therefore, requesting laws, in so miscellaneous petition is concerned, but the valuation will not arise. In fact, not commitment is marked on the order sheet, which is subsequently obtained. Adil court fees ಬರೋದಿಲ್ಲ.
No, court fee barala.
ಅದಕ್ಕೆ valuation ಬರೋದಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳೋದು. What happens
Even if it is, there is no court fee, but you have for the purpose of jurisdiction, pecuniary jurisdiction, you have to give that value of that property. That I got. See, jurisdiction has been decided on not on the value of the property.
That is true. That is true.
Then you have to give that value of the property here itself. Give that value, then obviously this. Yes.
Right.
Council for petitioner pays 2 days time to comply that office objection. 21.
They complain, what they are asking is, but
compliance in the manner that they have said would not be possible. If a lot may say, I may be permitted to legal. As of now, they will not give us the file for compliance. So not to give me 10 days time. Not with liberty to make submissions not in the report.
Others, see, whatever the obvious objection you can comply, remaining again it will post it before the court. See what there is, if they given a valuation, they will given a classification saying that since it is more than 15 lakhs, it has to be placed before the division bench. Then I have to decide other objection whether the single judge or a division bench. I will have it. I will say that week's time is granted at the request.
Great, yes.
Number 27,
Take back that order.
Yes, yes, you take that.
Vivekananda case for appellant.
We have a petition. We have 19 days, my lord, an application has been filed.
Yes.
There are two other applications, my lord, one for the stay of the operation of the impugned order. And another application, my lord, to consider my order 39.
Yes, you take out notice.
What has happened is extreme urgency in the matter. There are two properties, my lord. I have filed a suit for injunction on property bearing number 6 and 7.
No, but there isn't a delay. Can I
It's
grant
just 19
interim?
days, my lord.
No, 1 day or 10 days or 100 days. Delay is delay. Can the court grant any interim order without condoning the delay?
Please, my lord, a status quo that the extreme
No, that is also
urgency.
interim order.
The trial of the suit.
No, you take hand summons. We'll have it next week.
Till then, my lord, there is an extreme urgency in the matter.
No, I
agree, my lord. I
Yes,
agree.
You convince me and give that judgment, then I will
I
definitely.
will not, my lord. The reason of even this 19 days delay was my suit itself was dismissed, my lord. At the time of adjudication of my application in order 39 rule 4. And I could not have filed this MFA. My lord, I went before the writ court.
Yes.
And your lordship may kindly see that order, my lord, at page 98, my lord.
No, this is
Annexure
the
Act.
case where the suit is pending. You take.
Now it has been restored, my lord. I could not have filed the MFA because there was no suit at all.
Yes.
Now pursuant to the order passed by a coordinate bench, my lord, at Annexure Act.
Now that your injunction order has been restored now, in view of that suit has been restored.
Now suit has been restored, my lord. Injunction has not been restored. Injunction was in my favor. That came to be, tinkered with, my lord, and 39 rule 4 came to be allowed.
39.
My lord, that is the reason why I could not have been before
No,
this.
you take hand summons to that counsel appearing in the trial court.
Lord, I will do that, my lord, but there is an extreme urgency.
No,
But the reason I am assigning, my lord, the compelling reason.
No, you show me that this court has any power. Then I will definitely consider. Because in other cases also, so many is arguing. Somebody has to assist me.
Lord, that is it.
In tomorrow onwards, I will not ask this.
I
question.
bow down, my lord. The distinction here is I could not have filed the MFA.
No, all that distinction, the main question is pending consideration of delay, can this court pass any interim order? If there is any such law, you give it, it is helpful for me. So many
I would not,
advocates.
I would not like to take.
Somebody has to
I
assist. Yes, but so far, it's my understanding, I think court has no jurisdiction to pass any interim order when delay is there.
If there was a delay because of the reasons assigned up to me, my lord, I would have understood, my
No,
lord, because there was
is
no
no
suit.
such distinction in the delay. When condoning the delay, that may be the ground. But when there is a delay, I think some Supreme Court judgment is also there.
But delay may kindly be condoned, my lord, at least.
Without issuing notice, how can that? That cannot be. That is a good ground to set aside my order.
I leave it to this.
Yes, I want assistance of the lawyers to see that my order has to be sustained, not to set aside by that higher court.
We will do that.
Yes, issue notice. In addition, appellant is permitted to take out hand summons to that respondent. Yes, you take an hand summons and move it.
Date kindly be assigned, my lord. any
No,
time.
that hand summons, if you take.
We will do that as early as possible.
They will give 5 days time. Because today I have seen this one matter. There is an hand summons 5 dina ಕೊಡ್ತಾರೆ. Then we have to wait for 5 days.
But any date might,
We'll have it on next Friday.
please,
Next Friday. By the time you take it today itself, then it will become 5 days.
extremely obliged.
Yes. It is.
Number 28, Anand Vivekananda for petitioner.
Therefore, the petitioner was the order of the registry in dismissing the petition on 22/5/2023.
What is that? You have a complaint of its objection.
Only thing is that I have to file the certificate, copy of the eligible copy of the certified copy.
Yes, I will grant time. You comply.
Please.
Yes. Pending consideration of IA 1 of 2023. Weeks time is granted to comply that of substitute.
Number 29, Anuradha Aras, MD for
There's a delay of 86 days. I think with notice period.
Yes, issue notice.
number 30, Lakshmikant K for petitioner.
My lord. 317 days.
Yes, notice.
Number 31, Vivekananda T for the petitioner, Akash Kumar Gowda.
Yes. Yes, what is this, Mr.? Have you filed any objection to that IA?
No.
Yes, only one respondent.
Yes.
There is a delay of 73 days. 31. 32, there is no respondent, Mr. ಯಾಕೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರ್ಸಲ್ವಾ ಕರೆಕ್ಟ್ ಆಗಿ ಯಾವ್ದಾದ್ರು ಅಂತ
ನೋಡಿಲ್ಲ. Well, you file an objection.
for 73 days is a petition from whom, Mr. Wife or
Filed by the wife.
wife? What is that order you are challenging?
Order by which not the maintenance of rupees 8,000 to the wife and 8,000 to the son is awarded.
You want enhancement?
I want enhancement.
Yes, what is that, Mr.? We will condone the delay 73 days. What is? We'll argue on that merit.
We file an objection.
ಯಾವ್ದಕ್ಕೂ objection ಏನಿಲ್ಲ, it's an only delay. We'll condone that. Yes, there is a delay of 73 days in filing in a petition. IA 1 of 2023 is filed for condonation of delay. Respondent has seriously objected for condoning the delay. Peruse that affidavit. For the reasons stated in the accompanying affidavit, delay of 73 days in filing a petition is condoned. IA 1 of 2023 is allowed. Office is directed to secure original records from the family court. Yes.
Number 32, Ranjan Kumar K for petitioner.
Notice. Delay in filing the appeal. IA first notice.
Number 33, Rajesh A for petitioner. Number 33,
Rajesh. Notice.
number 34, Mukesh B for petitioner.
Notice. Yes, both.
Matters, serial number 35, Gopal Singh for petitioner, Devaraj S.
On the petitioner below.
Yes.
It's an eviction case below. An
Yes.
eviction was ordered. The petition was filed by a trust below. The trust which is non-existent below. It was created in the year 1980 for a period of 15 years and it lapsed in the year 1995 below.
No, then who is your landlord?
The ownership is different person below.
Huh?
Ownership is different person. It is filed by a beneficiary of a trust below. In the name of the trust, the petition was filed. That
No, this
trust,
property has been given to the trust. Trust is not a owner.
trust is not the owner.
What is that defense you are taken before that?
The property was taken by the petitioner's father in the year 1950 million. It was very long back that NSC was created.
Yes.
And thereafter, there was an understanding between the petitioner's father and the one person who had owned that property. Million.
Who is that one person?
This is Mr. Kapoor Chand. Million.
Kapoor Chand.
Yes.
Is it property has been given to the trust?
Yes, ma'am. Registered in name of trust.
Huh?
Registered in name of trust, 1983.
No, it is trust property. Then
The trust which
whoever may be your landlord, after that it is transferred to the trust. They will step into the shoes of that landlord.
But a beneficiary has filed this petition below, not the trustees.
Trust only filed, not beneficiary.
No, that person who has deposed before the court and who had led this prosecution is a trustee, he is a beneficiary. He is not the trustee.
Now that managing director,
No, Milord.
managing director is representing.
He has given that caption, Milord, but under exhibit P6, which is the trustee, Milord, there this person's name is shown as a beneficiary, and he is not a trustee.
Who is that?
He was a beneficiary, subsequently he continues as a trustee, and he was interested in the job of running trustee. There is admitted fact in the constitution by the no record.
No, that now he is a managing trustee.
Yes, Milord. It's admitted fact. No record should place, Milord. No, Milord. This is sorry. He's
Have you taken that objection?
Yes, Milord.
You have filed that trustee.
Yes, Milord. It's marked. It's marked. Yes, Milord. That is exhibit P6, Milord. No, Milord.
Otherly, he is not a managing
No, Milord.
trustee.
No, Milord.
Yes, you have the copy.
My lordship perused the written statement of the petition. It clearly discloses what is the case of.
Then you will secure the records. Yes.
It is here, my lord.
Give the trustee.
I'll read the written statement of the petitioner herein, so that can give the insight of the tables of the petitioner. This is written statement filed by the defendant before the court, trial court, my lord. That be permitted reading. Cause that father defendant Sri Astima during lifetime had occupied the shop premises bearing number 3, so and so, so and so. It is also submitted the father of the defendant Sri Astima had occupied the entire building, then measuring built up area of 2,500 square feet in the property. Cause that father of the defendant had monthly rent of ₹500 revised to present rent of ₹1,500. But it is true that the last paid rent is ₹1,500 per month. Other allegation made in paragraph 3 unpaid is denied. Cause that plaintiff intended to demolish the structure that stands at present and wanted to build new one. Cause that the month of August 2015, the defendant and plaintiff demanded the defendant quit vacate and hand over the vacate portion of the property mentioned in the schedule of the plaintiff. Cause the defendant agreed to pay any of the demand of the plaintiff. Cause the defendant did not pay the rents to the owner. Now, my lord, submissions. It is to submit that the defendant attended rents as and when it became due, but rents were refused. Even defendant tenants tendered the rents by check and by list post, which was refused. Even after notice addressed by the plaintiff to defendant 3/4/2019, demanding rents of 66,000, and even after payment of it by check along with reply date and 4/2019, the plaintiff not encashed the check. Refusal on part of the plaintiff to receive the rent is explained. The defendant is not at fault for anything. Defendant paid the rents for use of the property. Here, he admits that ownership is
That there is you are not in a right person to represent the trust.
Yes. But written statement clearly says that
I
they're not doing so.
No,
They are-
law is that
Yes, my lord.
right person has to be represented. ಯಾರೋ ಒಬ್ಬ ಬಂದ್ಬಿಟ್ಟು ನಾನ್ ಟ್ರಸ್ಟಿ ಅಂತ ಟ್ರಸ್ಟ್ ಪರವಾಗಿ ಕೇಸ್ ಹಾಕಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ, ಹಂಗಾಗಿದ್ರೆ they would have taken the stand in the written statement.
No, that is an illegal.
Yes, ma'am. Next,
You are
ma'am.
a trustee. You are managing trustee.
Yes, my lord.
Where is the documents, Mr.?
Next, my lord. I'll come to that next paragraph.
Now you show me that.
No, it is written statement. I'll come to the document later. Para 7, where it
check
says
if that-
defendant submits that.
No, I have to see that records.
Yes, my lord. Yes.
Office is directed to secure original records from the trial court forthwith. Yes. What stay?
Execution there. No, I'm not going to enforce that. It's okay.
Yes. Yes.
Number 36.
Much of this.
Please, Rambalingappa.
This name is petition law.
Yes.
There are two suits, my lord, filed by the plaintiff.
Yes.
One is, my lord, the OS number 3142 of 2022, in page number 37.
Yes.
This is a simple prayer injunction for, my lord, restraining them to interfere with peaceful position enjoyment of the property of the plaintiff.
Yes.
Then, my lord, what, my lord, this injunction was granted.
Yes.
Then, my lord, ultimately injunction was rejected. We have approached this honorable court.
Yes.
This honorable court, some order.
Yes.
Your lordship disposed of, directing dispose of the original suit OS number 3142 within summer vacation. Thereafterwards, your lordship extended.
Yes. Yes, I can remember that.
Yes. Ultimately, what happened, my lord, another suit for declares, they have produced series of documents in the trial court. And ultimately, my lord, in page number 56, they have created in between the family, there are partition, release deed and all these things. Therefore, my lord, the plaintiffs have filed a suit for declaration. Prayer is, my lord, in page number, my lord, 74. We have sought a declaration declaring that those deeds, the several deeds, my lord, executed in between the family.
No, you have filed another suit.
Suit for comprehensive declaration suit. That suit is pending before, my lord, another court, quota number 13. This injunction suit is pending quota number 16. Then we have approached principal civil judge, my lord, in page number 16 is the order. By filing miscellaneous petition to, my lord, club both case, withdraw the injunction suit. Injunction suit ಏನಾಗ್ತದೆ ಅಂತಂದ್ರೆ ತಮ್ಮ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ, we can't withdraw. ಇಂಟ್ರಿ ಮಾಡ್ರ ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದ್ರಿಂದ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಡೈರೆಕ್ಷನ್ ಇರೋದ್ರಿಂದ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಗೋದಿಲ್ಲ. ಕ್ಲಬ್ ಮಾಡಿ ಟ್ರಯಲ್ ಆಗ್ಬೇಕು.
ಯಾಕೆ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ಲ?
ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳಕ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಇದೆ ಅಂತ ಹೇಳಿ ಆ ಕೇಸಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ.
No. That is to see. Now you can file a withdrawing the suit since you have filed a comprehensive suit for declaration and injunction.
ಏನಾಗಿದೆ? With great respect to this court, we have approved this court. ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ,
till maintain disposal of the suit, status quo to be maintained.
That doesn't mean that suit cannot be withdrawn.
ಆ ಸೂಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಇನ್ನು ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಸಿನ್ಸ್ ಮೆಲಾಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಪಾಸ್ಡ್ ಆರ್ಡರ್ ಅಂಡ್ ಮೆಲಾಡ್ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಆಗಿರೋದ್ರಿಂದ ನಾವು ಅಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಕೊಡಕ್ ಬರಲ್ಲ, ಸೆಕೆಂಡ್ ಇಂಜೆಕ್ಷನ್ ಆಗ್ತದೆ ಅಂತ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ. ಈಗ ಏನು ಸೂಟ್ ವಿಡ್ರಾ ಮಾಡಿದ ತಕ್ಷಣನೇ ಎಂಟೈರ್ ಆರ್ಡರ್ ಇಲ್ಲ.
Then you have to file a separate application.
ಅದಕ್ಕೆ ನಾನು ಏನ್ ಮಾಡಿ
And you can take this also advantage that there is already an order. Then court can.
ಸಿನ್ಸ್ ಮೆಲಾಡ್ ಹೈಕೋರ್ಟ್ ಮಾಡಿದೆ ಅಂತ ಆದ್ಮೇಲೆ ಅವ್ರು ಕ್ಲಿಕ್ ಹೋಗುದು.
That is only a status.
My respectful submission is withdraw that non prayer, withdraw club it with the other comprehensive. ಅಷ್ಟೇ ಕೇಳಿದ್ದೆ. ಸಾಹೇಬರು ಏನ್ ಬರೀತಾರೆ ಟ್ರಯಲ್ ಜಡ್ಜ್ ಇದರಲ್ಲಿ ಮಿಸ್ಲೇನಿಯಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ, ಸಿನ್ಸ್ MFA ಆರ್ಡರ್ ಆಗಿರೋದ್ರಿಂದ ಆ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಇದು ಬೇರೆ ಬೇರೆ ಆಗಿರೋದ್ರಿಂದ ಪಾರ್ಟೀಸ್ ಒನ್ ಅಂಡ್ ದಿ ಸೇಮ್ ಅಂಡ್ ಪ್ರಾಪರ್ಟಿ ಒನ್ ಅಂಡ್ ದಿ ಸೇಮ್, ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಒನ್ ಅಂಡ್ ಸೇಮ್ ಆದ್ರಿಂದ ನಾವು ಇಲ್ಲಿ MFA ರೆಫರೆನ್ಸ್ ಪೇಜ್ 9 ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ. Respondent has opposed this petition on the ground that there is no necessary to club the suits as prayed by the petitioner and that there is no merits in the ground urged in the petition. They have stated that if the petition allowed, the direction issued by the Honorable High Court of Karnataka in MFA 5292 up to become infructuous. ಈ ಗ್ರೌಂಡ್ ಮೇಲೆ ಸಾಹೇಬ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಇಲ್ಲಿ ಆರ್ಡರ್ ಇರೋದ್ರಿಂದ ನಾನು ಟಚ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Therefore, your lordship has got power. ನಾನು ಟ್ರಯಲ್ ತಮ್ಮ ಡೈರೆಕ್ಷನ್ ಪ್ರಕಾರ ಎರಡು ಮುಗಿಸ್ತೀವಿ. ಯಾಕಂದ್ರೆ
We'll say you may be permitted to withdraw this suit when there is a comprehensive suit. We withdraw that.
But interim order granted will not be continued till
ಅದು ಅದರಲ್ಲಿ
ಅದರಲ್ಲಿ ಏನಾಗ್ತದೆ ಈಗ ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ, ಈಗ ಸ್ಟೇಟಸ್ ಈಗ ಸೇಲ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಅವರು ಅಥವಾ ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ಪೊಸಿಷನ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ.
When you have filed a suit for declaration, then you have to file an application under 39(1).
ಅದು ಹಾಕ್ತದೆ. ಅದು ಆ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ತಾವು ಕೊಟ್ಟದ್ರಿಂದ ನಾವು ಪುನಃ ಮತ್ತೆ ಕೊಟ್ಟು ಅದನ್ನ ಡಿಫೀಟ್ ಮಾಡೋದು ಸರಿಯಲ್ಲ ಅಂತ. ದಟ್ ಇಸ್ ಆಲ್ಸೋ ಕರೆಕ್ಟ್.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದೇನು ಸ್ಟೇಟಸ್
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಗ್ರಾಂಟೆಡ್.
Same can be extended, order can be passed.
ಆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬಿಟ್ರೆ ನಾನು ಸೂಟ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
No, unless
ತಾವು ಸೇಮ್ ಡೈರೆಕ್ಷನ್ ಆ ಸೂಟ್ ಅಲ್ಲಿ ಕೊಡಿ, ಎರಡು ಸೂಟ್ ಅಲ್ಲಿ ಇದೆ. ಹಾಗಾಗಿ
now that
I am permitted to withdraw the suit 141 subject to the status quo to be maintained till disposal of the suit. ಅಷ್ಟೇ ಅದರಲ್ಲಿ. ಯಾಕಂದ್ರೆ ನಾಡಿದ್ದು 27th ಇದೆ ಅಷ್ಟೇ. ಈ ಸೂಟ್ ವಿಡ್ರಾ ಇಲ್ಲೇ ವಿಡ್ರಾ ಮಾಡಿ ಯಾವುದು 3-4 status quo to be continued with 2-1-8 of 2023.
no, in that suit also you are a plaintiff.
Yes,
Your order 39 rule 1 and 2 application reject ಆಗಿತ್ತಲ್ಲಿ.
ಅದೇ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಸೇಮ್ ಗ್ರೌಂಡ್
अपना आता था इसमें चालू कर देंगे बंद अपना
ಕರೆಕ್ಟ್. ನಾವು ಏರ್ಪೋರ್ಟ್ ನವರು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಅಲ್ಲಿ ಅವರು ಹಾಗಾಗಿ ನಾನು ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ಲ. ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಕಂಡೀಷನ್ ಆ ಇದರಲ್ಲಿ ಸಿಂಪಲ್ ಆಗ್ಬಿಟ್ರೆ, ಯಾಕಂದ್ರೆ ಟೂ ಟ್ರಯಲ್ ಆಗಿದೆ, ಟೈಮು ಇಷ್ಟು ಒಂದು ಎರಡನೇದಾಗಿ ಡಿಫರೆಂಟ್ ಡೈವರ್ಟ್.
No, you can't take this advantage and now declare
advantage. My respectful submission.
Declaration suit cannot be disposed of as a
my prayer, my lord, your lordship before this court, my lord, ಅದನ್ನ ಅಲ್ಲಿಗೆ ಹಾಕಿ ಅದೇ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ, ಡಿಸೆಂಬರ್ ಒಳಗೆ ಕ್ಲೋಸ್ ಮಾಡಿ. ನಾವು ಕೊಟ್ಟಿದ್ದೀರಾ.
Now you take notice, take other side.
ನಾಳೆ till Monday.
No, that is your case. It is
trial.
It is good. Why do you want to stay your suit?
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಆಗಿದೆ, ಸೂಟ್ ಡಿಫೀಟ್ ಆಗಿದೆ.
ಹೆಂಗ್ ಡಿಫೀಟ್ ಆಗುತ್ತೆ?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಸಿಂಪಲ್ ಇಂಜೆಕ್ಷನ್ ಇದೆ, ಅದ್ರ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎವಿಡೆನ್ಸ್ ಅದ್ರಲ್ಲಿ ಕ್ರಾಸ್ ಇದೆಲ್ಲ ಆಗ್ತದೆ.
No, injunction suit, now that you are challenging that order passed by trial court under application 24, you take notice. That cannot be.
ಅಲ್ಲಿ ತನಕ not
Injunction suit is not in a before me, I cannot.
ಅಲ್ಲ ಎರಡು ಕೇಸಲ್ಲಿ.
No, application is filed in which case?
Both case.
Which case?
That is my lord to club in both cases.
No, you take handsome to
ಅಲ್ಲ both case ಅಲ್ಲಿ ಇಲ್ಲಿ
let them. I can't pass order contrary to my earlier.
ಅಲ್ಲ ನಾಳೆಗೆ ನಾನು ಹೇಳಿದ್ದು
you do evidence, you take an handsome.
ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
No stage. Let's issue notice. This is the, see, real tricks are playing by that parties. You know that you are filing that injunction suit. Here made the submission. Senior counsel has appeared.
Yes.
That will complete that suit.
Yes.
Status quo may be maintained.
ಹೌದು.
We'll
ಅದರಲ್ಲಿ
let that other side come.
ಒಂದು ನಿಮಿಷ ನಾನು ಮೆರಿಟ್ ಏನಾಯ್ತು ಅಂತ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ದಿಸ್ they have produced kindly see for a moment with great respect to this court kindly turn page number 74.
Yes, I will serve a copy. We'll
ಅಲ್ಲ
take-
ಕಾಪಿ ಸರ್ ನಾಳೆ
No, no
not to
improvement.
participate ನಾಳೆ
No,
ನಾಳೆ ಕ್ರಾಸ್
no, it is against my.
ನಾಳೆ
No, let you do it. Do it. It is
ಹಾಗಾದ್ರೆ
not-
ಬುಧವಾರ ಆಗಿ
On the-
ಟ್ರಯಲ್ ಕೋರ್ಟ್
See-
ಅಡ್ವೊಕೇಟ್ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್
On consideration of the parties, I myself has passed an order, complete before summer vacation. Then, no, must.
ಅಲ್ಲ 74 ಪೇಜ್ ಒಂದ್ಸತಿ ನೋಡಿ
I
74
read,
ಇದೆ ನೋಡಿ
see, as long as if it is from Monday, roster is changed, you can get it interim order. It is not before me. No interim order will be granted.
ಮಂಡೇ
It is-
ಚೇಂಜ್ ಆಗುತ್ತೆ
Allah, if it is changed, you can get it.
ಇಲ್ಲ,
by
ಇಲ್ಲ,
other
ಇಲ್ಲ,
court.
ಇಲ್ಲ.
It's not.
ಅಲ್ಲ ಬುಧವಾರ
This
ಹಾಕಿ
is not the way.
ಅಲ್ಲ ಬುಧವಾರ ಹಾಕಿ ನಾನು ಅಡ್ವೊಕೇಟ್ ಟ್ರಯಲ್
No.
ಕೋರ್ಟ್ ಸರ್ವ್ ಮಾಡು
Yes, you serve, take in hand summons.
ಬುಧವಾರ ಕ್ಯಾನ್ಸಲ್
No, 5 days time has to be given after hand summons.
ಬುಧವಾರ ಯಾಕೆಂತಂದ್ರೆ ಅಲ್ಲಿ
Yes.
ಇದು 84 ಒಂದ್ಸತಿ ನೋಡ್ಬಿಟ್ರೆ ಪೇಜ್
When that
ಐ
considering,
ಆಮ್ ನಾಟ್ ಪ್ಲೇಯಿಂಗ್ ಎನಿಥಿಂಗ್
no, when considering before this court, this has been made as a plan to see
ಅಲ್ಲ
that
ಪ್ಲಾನ್ ಅಲ್ಲ
declaration has to be filed.
ಪ್ಲಾನ್ ಅಲ್ಲ ಒಂದು ಚೂರು ತಾವು ನೋಡ್ಬಿಟ್ರೆ ತಮ್ಗೆ ಅರ್ಥ ಆಗ್ಬೋದು 75 ಪೇಜ್
I know.
75 ಪೇಜ್ ಡಿಕ್ಲರೇಷನ್ ಏನೇನ್ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದೀನಿ ಒಂಚೂರು ನೋಡಿ.
See, legislator has a power to overcome that judgment of the court. They can make any legislation like that now that to overcome that court order. You are
ನಾವ್
doing-
ಅಂತ ಟ್ರಿಕ್ಸ್ ಎಲ್ಲ ಮಾಡುವಂತವ್ರಲ್ಲ ಒಂದ್ ನಿಮಿಷ 75 ನೋಡಿ ತಮ್ಮ
This is not-
ಮನಸ್ಸಿಗೆ
not for
ನಾವು-
advocate.
ಅಲ್ಲ ನಾವು ತಮ್ಮ
Parties
ಮನಸ್ಸಿಗೆ
are more clever now.
ತಮ್ಮ ಮನಸ್ಸಿಗೆ 75 ಪೇಜ್ ಒಂಚೂರು ನನ್ ಸಮಾಧಾನ
See, after appearance of both the parties,
Yes.
we'll see that. If it is permitted, then parties are agreed in the declaration suit can be early disposed of,
Yes.
then I can make an order. Before that, I don't.
ಅಲ್ಲ 75 ಪೇಜ್ ಒಂಚೂರು ನೋಡಿ
No, I know. I
ವಿತ್
can.
ಹಾನೆಸ್ಟಿ ನಾನು ತಪ್ಪು ಮಾಡಿದೀನಿ ಹಾಗೆ ಒಂಚೂರು 75
Yes, you take handsome.
ಎಲೀಜ್ ಕನ್ಕಾಕ್ಟೆಡ್ ಒಂದು ನಿಮಿಷ
Yes.
sorry ಎಲೀಜ್ ಕನ್ಕಾಕ್ಟೆಡ್ book created unregistered GPA dated so and so and dated and I declared that then and when on the basis of concocted GPA the sale deed dated 2000 ಆಮೇಲೆ ಹೆಂಡತಿಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ಪುನಃ ಮತ್ತೆ ಅದೇ ಪ್ರಾಪರ್ಟಿ ಪಾರ್ಟಿಷನ್ ಅಮಂಗ್ ಚಿಲ್ಡ್ರನ್ಸ್ ಮಾಡ್ತಾರೆ ಇದೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಿತ್ ಇನ್ ದಿ ಫ್ಯಾಮಿಲಿ ಹಂಗಾಗಿ ನಾನು ಅದಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ಕೇಳ್ಬೇಕಾಗಿ ಡಿಕ್ಲರೇಷನ್ ಹಂಗಾಗಿ
No,
ಅದರ್ವೈಸ್ ನಾನು
no, all this has been stated in the written statement, is it?
ಯಾವ್ದ್ರಲ್ಲಿ
Now that they have taken all.
ಆ 3142 ನಲ್ಲಿ ಹಾಕಿದ್ರು ಆ 3142 ನ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ they have come before these documents immediately we have approached this court and when this honorable court ordered when all these documents now ನೋಡಿದಾಗ ಇದಿಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕ್ರಿಯೇಟ್ ಆಗಿದ್ದು ಗೊತ್ತಾಯ್ತು
Avagale you know that
ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಹಾಕ್ಬಿಟ್ರೆ ಇಮಿಡಿಯೇಟ್
before when you are seeking for an injunction, you are already thought that it is the suit for declaration is necessary.
ಹಂಗಿದ್ರೆ ನಾವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ತಮ್ಮ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಸ್ತಿದ್ವಿ ನಾವು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ ಅವತ್ತು
Let
ಗೊತ್ತಾಗಿದೆ
us see that you take.
ಅದು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ದು ಅವರು ದೇ ಹ್ಯಾವ್ ಕನ್ಸಿಡರ್ಡ್ ವಿತ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್
Yes.
ಬೈ ಹ್ಯಾಂಡ್ ಕೊಡಿ ಬುಧವಾರ
Yes, issue notice in addition. The appellant is permitted, petitioner is permitted to take hand summons to respondent number 1 to 4.
ಅಲ್ಲ ಒಂದು ಅಡ್ವೊಕೇಟ್ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಇನ್ ದಿ ಟ್ರಯಲ್
Avರಿಗೆ hand summons.
ಅಲ್ಲ ನಾನು ಸರ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಡೈರೆಕ್ಷನ್
Yes,
ಅಡ್ವೊಕೇಟ್ ಇಸ್ ಅಪಿಯರಿಂಗ್
issue emergent notice in addition. Appellant is, petitioner is permitted to serve a copy on the council appearing for respondent number 1 to 4 before the trial.
ಪ್ಲೀಸ್
Post this matter on Thursday.
ಐ ಆಮ್ ಸಾರಿ ಟು ಪ್ರಾಕ್ಟೀಸ್ ಅಲ್ಲ ವಿತ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿಸ್ ಕೋರ್ಟ್ ಯಾಕೆಂದ್ರೆ
It appears.
ಅಲ್ಲ ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನಾಗ್ತದೆ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋರಿಗೆ ದಿಸ್ ಇಸ್ ನಾಟ್ ಮೊದಲು
No, I'm not blaming any council.
ಅಲ್ಲ
Now, council has no any personal interest.
ಗೊತ್ತಾಗೋದಿಲ್ಲ ಮತ್ತೆ
Council has no personal interest in that case. I don't think I will never blame any council because they don't have any personal interest. If the parties comes, ಇನ್ನೊಂದು ಇಂಜೆಕ್ಷನ್ ಹಾಕಿ ಅಂದ್ರೆ ಹಾಕ್ತಾರೆ, ಡಿಕ್ಲರೇಷನ್ ಹಾಕ್ತಾರೆ, ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಹಾಕಿ ಅಂದ್ರೆ ಇರ್ತಾರೆ. Lawyers is there for that.
ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟು ಹಾಕುವಾಗ ಜಿನಿಯಾಲಿಟಿ we have paid huge court fee 2.59. Court fee ಕಟ್ಟಿ ಮಾಡುವಾಗ
No, I see our written statement ಹಾಕ್ದಾಗ್ಲೇ he has realized that the comprehensive suit is necessary for declaration. ಅವಾಗ ಇಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಬಾರ್ದು.
ಮಾಡಬಾರ್ದಾಗಿತ್ತು.
When you are know that I have to file a declaration suit, ಇಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಮ್ಮ ಹತ್ರ ಸ್ವಾಮಿ 3-4 ತಿಂಗಳೊಳಗಡೆ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ತಗೊಂಡ್ಬಿಟ್ಟು then you file a declaration suit. Now you want to club it to overcome that my entry matter.
ಅಲ್ಲ ಅದರಲ್ಲಿ ತಾವು absolutely ಈ suit to dispose back in the party are
Declaration suit cannot be disposed of 3 months. I can't say that same entry matter will be continued here. Ultimately, that entry matter will be dispose ಮಾಡಿ ಅಂದ್ರೆ entry matter will be extended for another 1 year. Here, both the parties has agreed 3 months ಆದ್ರೆ okay ಸ್ವಾಮಿ ನಮ್ದೇನೋ ತೊಂದರೆ ಇಲ್ಲ. I will not put up any construction ಅಂತ they are agreed. Now it will goes to 1 year. ಆಯ್ತು ಏನೋ ಒಂದು ಯಾವ್ದೋ ಒಂದು ರೀಸನ್ ಅಲ್ಲಿ ಹೇಳಿರ್ತಾರೆ ಅವರು 3 ತಿಂಗಳಿಗೆ ಇಟ್ಸ್ ಓಕೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು let us see after appearance if they are agreed I have no objection.
ಎರಡು ಟ್ರಯಲ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಲಿ ಅಂತ ಎರಡು ಕಡೆ ಟ್ರಯಲ್ ಮಾಡ್ತೀವಿ ಅಂತಲ್ಲ ಪರಿಸ್ಥಿತಿ ಕೋರ್ಟ್ ಆಗಿತ್ತು.
No, it is not that waste of court time is secondary. First, interest of the parties, right of the parties right has to be seen first. Court time waste ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಿಮಗೆ ಹಂಗಾರೆ ಯಾವನ ಪಾರ್ಟಿ ಕೇಸ್ ಹಾಕಕ್ ಬಿಡಬಾರ್ದು, ಹಂಗೆ ವಾಪಸ್ that will see on that merit will see that after appearance of the parties. Yes, because I have not seen when that written statement has been filed, when they have taken that contention. After assistance of that other side, I can. Yes. Yes.
For the respondent for one.
Yeah. Yes. Yes. No, that who are you? You are also one of the co-partner or what is that application you have filed? Yes. So this application under 39 1 and 2 has filed in that FDB. Who has filed? Plaintiff. Degree holder. It's an S. Yes. Can stage ali the FTP? No. No, this property where now that status has been ordered. That no, that now that preliminary degree has been passed. No, see, is this property is also part of the preliminary degree. Then, no, is there any observation in the preliminary degree? This property has to be allotted to you. Now that has to be decided by that FDP. Show me that where is that order? If partition is already upheld, then there is no question of passing in another this thing. Tara? Yes. Yes. Hmm.
Knowledge of the condition and stages and they are indicating of the further. With the present item of the or the action to complete the permission. The item of. Father, acted upon to the father with the knowledge of the man. Not and to the lifetime of the father up to 1989 and that did not challenge its 1970. This partition in building and other properties 19 to 19 other properties dependent contain two in room, two in the room, and also have put it into control of licensing and the house. Under these circumstances, they have no right and interest in a chair as the father made in 1999. The other observation may be also.
No, see, answer issue number 1, 5, and 6 is partly is affirmative.
At page 22.
Page.
In page 16.
Hmm.
When it may be, does it burden on the plaintiff, whether the plaintiff is entitled to the release of relief to declare that the
Which
partition or settlement is dated 2017-19.
No, which issue you are reading?
Issue
7. Yes. Whether the plaintiff is entitled for the relief to declare that partition settlement is dated is not binding on the. What is the answer? Issue number 7. Hmm.
1972, then 40 years back.
What is the preliminary degree? No, yen ಮಾಡಿದಾರ್ರಿ. The claim of the plaintiff in the item number 1 to 6 properties is dismissed. 1 to 6 is dismissed.
Share of his father. One third share along with other dependents in item number 17 to 19.
Hmm.
They only entitled 1/6 share out of 1/3 share of the father. He was not pretending the property.
The plaintiff is entitled to 1/6 share in her father's share of 1/3.
Father share is 1/3.
No.
Item number 30, the construction is completed and 23,000.
ಅಲ್ಲ ಈಗ ನೀವು ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ ಅಲ್ಲಿ? How many children's?
6.
2 sons. What are the plaintiff is entitled? Who are the plaintiff? Only one daughter, huh?
4 daughters.
Indra Devi is the plaintiff. The plaintiff is entitled 1/6 share. There are 6 ಅಲ್ಲ. 1/6 share in the father share of 1/3. ಅಂತಂದ್ರೆ ನೀವಿಬ್ರು ಸರಿ ಒಟ್ಟು 3 ಶೇರ್ ಆಗುತ್ತೆ. 3 ಶೇರ್ ಅಲ್ಲಿ ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತಿರೋದು? ಒಬ್ಬನೇ ಮಗನಿಗೆ ಮಾತ್ರ. No, that you are only 1/3, you are entitled for 1/3. Wait. You are entitled for 1/3 plus in the 1/3, 1/6. 1/3 plus 1/6. 1 by 18.
Equal judgment was of the year 2019.
ಅಲ್ಲ ಈಗ ಆಯ್ತು ಈಕ್ವಲ್ ಶೇರ್ ಬಂದ್ರು ಕೂಡ now that not 1/3, now that Supreme Court said in the final degree proceedings also you can apply that Vinita Sharma. Now that he will entitle 1/6 share. Now that property which he is constructing, it is that within that 1/6 share, let him do it.
No, for the entire property. For the trial party claims that it is in respect of
Yes.
However, it is an illegal construction.
No, now that, see,
Plan and
all are, wait, that will come to that later. When I permitting them to construct, then we'll see that. Now that these properties all are having in a right. No, see, now that,
You have to see the judgment. Judgment of the trial court, they are not having any share because the partition has been upheld.
no, now that 1/3 share of the father, because that in view of that earlier Vinita, before Vinita Sharma. Now in view of that Vinita Sharma, they are entitled for equal share.
As per, if there is no partition, if there is earlier partition. Partition took place, the lordship may kindly see the partition took place in year 1973. Registered partition deed. My
Then
father
now-
was alive at the time. Father got share, myself got there, my brother got the share.
You are already having the share. Now that
Okay.
they are only entitled in the share of that father.
Only entitled father's
Now
share.
that
That's
partition which has been taken place before that amendment cannot be
Right.
reopened.
That is 73.
Now that they are entitled only 1/3 share in that father property.
The share the father's property.
Only now what to say about other brother? Other brother is entitled for the
No,
same.
other brother got other properties in the partition. He is having a rice mill. And I am a coal pump. And I have a sawmill.
No, but ultimately court has to decide whether.
The question is
each
stopping
portion-
me. Yeah, that's right. Stopping me from putting up construction which is already completed. You Rosh may put a writer on me. Stating that I'm accountable in the final degree proceeding as per the.
Now that how much time will take to dispose of the final degree proceedings? You will direct the trial court to dispose
No,
within
no,
that.
there's a status quo. They have filed RFA, we have filed RFA. 2 RFAs are pending.
You are challenging that also.
One RFA, we have filed the cross appeal.
Cross appeal, that's numbered as RFA.
Only one RFA.
Sir, that is numbered as RFA, sir.
Share.
Cross appeal ಹಾಕಿದ್ದಾರೆ. That cross appeal has been numbered as RFA.
Now that it is not under final FDP, now that RFA has to decide.
Or said till the disposal, see, I put up a construction, I will not claim any equities because I have already, I have borrowed 7 crores from the bank. I have already.
What is that RFA number?
Construction.
34 of 21.
Yes, I.
34.
The rulings of the Supreme Court, yes, I will find it. As per the find.
That when RFA is pending, so we don't know that there may be a modification of that judgment. Then we don't know who will get how much share.
No, I will not claim equities. I am only putting up construction there. I will not claim any equities. In RFAs. Yes, I point out 2 apex rule.
Now that let him construct undertaking that if it is if you are successful.
No, man, it is an illegal construction.
Like
No,
it
Mr.
says, the plan is there.
Without clarity, it is illegal.
The construction is illegal, let them demolish it. If the construction is illegal, let them demolish it.
That will not permit them to construct illegally, only in accordance with law. If there is any illegal construction, you go and give a complaint to that
No,
BBM.
let it pass. If there is any license.
Have you obtained the plan?
So plan and license, I got plan and license, according to plan and license, I am putting up construction.
Produce that.
Let it
First, I produce the plan and license.
Let us see that. Produce that plan and license. Then we'll see. We'll,
Lordship, I have done Monday.
Monday.
Monday, Ramnagar only.
Yes, Monday. Yes. Thursday, not Wednesday, Thursday. Yes. Produce the plan and give a copy to them also. Let them also. Yes.
I give a copy to them.
Yes.
38 Keshavapati appellant.
Appellant.
Yes.
I have also made an application without my participation.
What is this, Mr.?
First, we kindly take the plate, my lord, it is at page. Page 60.
60. Yes.
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 Pavitra. He was married to Suresh Chatan. She is the second wife of that Suresh Chatan.
No, she is married to?
Suresh Jatan, wife of Suresh Jatan, I have mentioned.
Yes.
And the other two appellants are minor children, my lord, from Samartha yes Jatan and Sinchana yes Jatan.
Yes.
My lord, this man had earlier married my lord, the Shailaja, first respondent.
Yes.
And she had
No,
a son
that,
also, my lord, second respondent.
He is not a party.
Pardon?
He is not a party.
He is a party.
Suresh Jatan.
He is now no more.
No more. Yes.
But this Saurabh Jatan is the son by the first wife.
First wife.
First response.
Now that first wife and the children and the second.
Yes, sir, now the dispute.
Yes.
My lord, after he died, my lord, he was residing with his second wife, my lord, because there was a strained relationship with the first wife. First wife was living in Mangalore, first wife and son. They were living in Mangalore, my lord. He
No, you are the first wife.
I am the second wife.
You are the second.
I am the second wife.
Yeah.
Now, my lord, he became unwell, my lord, admitted to hospital at Udupi, and then my lord, he shifted, my lord. Son was in contact with the father, occasionally coming, my lord, he was provided, he was educated, he was given a hotel, car, everything, my lord, in Bangalore, they are very rich business. But after his death, now, my lord, immediately he went and filed initially a suit saying that, my lord, he has left intestate, these are strangers. They are first, second wife and children are strangers. They have no right. I don't know who are they are, and therefore I succeed. Kindly see that plain. My lord, it is a annexure C.
What is the suit for?
But suit now, my lord, for a declaration that he has executed duty. He has
In the favor of second wife.
And second wife and children. He has provided to the first wife and children, his son also. But kindly see this interesting fact. Not annexure C. Not address is in Mangalore.
See page
47. Annexure C 47.
Yes.
But in the suit he says, my lord, kindly come to page 51. Para 11.
Yes.
But the plaintiff said Suresh Jatan, husband of the first plaintiff and father of second plaintiff, died intestate on 10/10/2020 at KMC Hospital, Bank.
Yes.
But he says there is no will, he died intestate. Because they didn't know that there is a will and all that.
Yes.
And my lord filed an application for injection all. Secondly, my lord, he says in the next para, your lordship will kindly see. The plaintiff said after his death, all his last rituals were performed at Udupi because he was at Udupi.
Yes.
What he was. And on the Saturday, the first dependent, along with the dependents 2 and 3, appeared and found in the vicinity proclaiming that they are the wife and the children of the deceased. It was utterly shocked to the plaintiff, and they were strangers to the plaintiff and their family. So and so. Para 16 also, my lord, is strangers, and his prayer is, my lord, to that he has succeeded to the perpetual injection, restraining us. Then my lord tried to take, my lord, fortunately no ex parte entry mod was granted in that suit.
Yes.
But after thereafter, my lord, forcibly, my lord, my children, he is little, my lord, second wife is not that educated also, children are minor children,
Yes.
going to school, elementary school. Then, my lord, I filed a suit for injunction and declaration out, my lord, that there is a registered will executed by this man, which I have produced, attested by 3 persons, registered, and he has provided to his sister, etc. I have produced. Then, my lord, in the said suit status card, I have given the list of all the, kindly see this plate which I have filed, annexure demon.
Yes.
OS 13 of 21.
Yes.
What address, manual, everything I have list of assets left behind by him, my lord, I have given the list, all the documents, everything.
Yes.
But there is a bank locker also, my lord, I am the nominee under the bank locker.
Yes.
And my lord, there is a petrol bunk and a commercial complex. Market was coming up, but crore rupees loan was there. Now, my lord, to this suit also, he says, I am not the wife.
Yes.
And strangely, my lord, his case is that, Lord, I have said, my lord, on 10th and 12th, Lord, kindly come to para 9. He says now, first, my lord, he has said in his suit that he died intestate. Now he says there is a bill executed by Suresh Jatan in 2015 after the bill which I have set up.
After that, your suit.
After my suit in the written statement.
Return statement.
In the written statement, kindly para 9.
Para 9 of.
Written statement, page 100 to my suit.
Yes.
But this defendant do not admit the truth, validity, genuineness, and binding the nature of the alleged registered with dated date for 2010 that is set up by me.
Yes.
Alleged to have been executed by late Suresh Jatan. The plaintiff cannot take advantage, benefit out of the said disputed document. This defendant denied that Suresh Jatan had left behind a registered with dated 8/4/2010. As stated supra, the deceased Suresh Jatan had left behind him only will dated 16/4/2015, as per which the provisions were made by the deceased for disposal of all his assets, etc. The said will dated 16/4/2015 is the genuine and last will, and properties left behind by the deceased Suresh Jatan have to be dispersed. Therefore, to overcome that earlier will, my lord, now he has fabricated a will.
Yes.
And my lord, kindly come to next one. He says the original this will which he has set up was stolen by his car from me, my person.
Yes.
That is interesting. But that is at the page 101.
Yes.
101 top paragraph. Second line I am reading.
Yes.
After the death of Suresh Jatan, the maternal uncle of the relative of late Suresh Jatan, in collusion with the plaintiffs, using the plaintiffs to their tunes, have sent forward to make the present false claim by filing the present frivolous suit. And after the death of Suresh Jatan, those persons having come to know about the will dated 16/4/2015, executed by the deceased, sent their rowdy elements, and they have stolen the original will and other valuable documents from this defendant's car. When he had parked his car at Mangal, immediately the defendant has lodged a police complaint and all that, my lord. This is how he is. Rowdy, he is a rowdy, my lord. I will point out. Now, my lord, these people are totally innocent. This entire case is, my lord, that kindly see next page, page 104. Their top last few sentences in para 14.
Yes.
That hence Suresh Jatan and the first defendant were never separated. Your lordship gets it now. Were never separated at any point of time. That is, he says they were living together.
Yes.
Till his death. That Suresh Jatan and this defendant and his mother have been living together as a family till then. Even though the Suresh Jatan had initially filed a petition for divorce, not there was a pending proceeding for a divorce restriction and all that. Divorce at the instigation and coercion by others, but in the meantime, he could realize the truth and as such, ultimately did not pursue the matter. The defendant said the deceased Suresh Jatan lived with happy. This is written statement. Now, but therefore, according to him, I am a totally stranger. Now, kindly see, there is voluminous document. Kindly come to page 140. The documents which I have produced to show that we were living together, I am the married wife. First document, my lord, this is the APL card.
Yes.
Page 114. Your lordship gets it.
Yes.
And Suresh Jatan. Second, next year, Pavitra. My lord, children's names are also mentioned. My lord, children aged Samartha Jatan, aged 6.
Yes.
And Sinchana Jatan. This is date, my lord, that is very important. 2013. My lord, right side.
This is your client.
Yes, yes.
Marriage certificate.
Yes.
Yes.
This is the APL card of that time, they were living. My lord, address also, your lordship may kindly note in this APL card, my Ravi Karan, opposite Indira Petrol Pump, Puttur. Village,
Any of that, it is all subject to that proof before the trial.
That's right.
Now, what is that issue?
Yes, Allah, there is voluminous documents, my lord. Now what happened was, my lord, kindly come to next, my lord, marriage registration certificate.
Yes.
Marriage registration.
Yes.
My lord, the lordship gets it, my lord.
Yes, yes.
Then, my lord, then birth certificate of both the children. Initial L and M. Just to satisfy your lordship conscious on Pavitra HL, my lord, the first child, Samartha.
Yes.
Then the next one is the daughters.
Yes.
Father's name is Suresh Jatan only, Sinchana. Then, my lord, the Aadhaar card of all the 4 members, my lord, address is it. These are all obtained in 2013-15. I am pointing out in one of them. Lordship may kindly see the dates also.
Yes.
In this Aadhaar card, 2013, Suresh Jatan. And, my lord, the next one is Pavitra Jatan.
Yes.
But that is also obtained in 2013-15.
Yes.
But dates are very small. It's mentioned there. I have, the lordship gets it.
Yes, yes.
Yes. Then, my lord, children's Aadhaar cards are also there. All address is same. Door number, Ravi Kiran, Puttur, opposite Indira Petrol, same. Then, my lord, there was a partnership business, my lord, registered partnership. My lord, your lordship will kindly see page 122. It is start.
Yes.
Not 122. My lord, second party is Pavitra HL, Vaibhav Suresh Jatan.
Yes.
Not Jatan RK. Now, my lord, then there is a declaration was also filed. Then, my lord, there is a license and all that for this part. What is the list? Page 164. Page 164.
Yes, there is a document to show that.
There is voluminous document. Now, my lord, status code. Now, what happened was, my lord, there is a petrol, which even after his death, he was running. My lord. This man, my lord, his wallet was taken. He was admitted to Mangalore hospital from Udupi hospital, saying that better treatment is there is some. He took it. Then, after his death, my lord, cash and wallet, everything was taken. And my lord, I was running the petrol. My lord, he objected to the petrol. Stop supply of petrol, saying that I was running it, and I was taking petrol and all that. Now, there is nothing to show that he was running the petrol pump. On the other hand, I was running the petrol.
Yes.
Then, my lord, this as far as partnership business is concerned, my lord, he has no voice because it is an independent business. Independent, my lord, both my husband and say partnership, my lord, I have borrowed.
Yes.
The construction is almost complete, my lord, which has been started. They are not financing now.
Yes.
We can't sell also.
Yes.
The lordship will kindly see this photograph. And loan interest is multiplying. Now, my lord, kindly see along with my, there is a bank locker.
Yes.
Petrol bunk. Now, my lord, to supply petrol.
Yes.
But as soon as amount is paid, my lord, I am told, my lord, that the agency will send a OTP number to the registered mobile. That is the usual practice. But he had taken that mobile because he died in the hospital, everything immediately, my lord, he had taken that. And that OTP had come to his mobile, which he has loaded, and therefore petrol was stealing. Taking advantage of that, he says, I was running the petrol. In fact, my lord, I paid 5 lakhs to the agency, my lord, to supply the petrol. Can you see, my lord, along with my application, I have produced my bank account. He may not know everything, every document with respect, there are other vast properties.
Your application is to injunction.
Injunction, my lord, or permit me to operate or to operate and function in the petrol world.
Where is that prior in that application?
Which one, man?
In the application filed before the trial court.
No, here.
No, what is that order you are challenging here?
Now, my lord, one, my lord, injection was application, my application was rejected, he was permitted to run the petrol work. That happened in repetition. Now, my lord, my application status order was there, that was rejected. I had got for an injection order to continue all his activities, my lord, saying that there is a will and all that. That application is rejected. Immediately, you were trying to forcibly, my lord, to open the.
No,
petrol
what is
bunk.
that writ petition you have filed against which order?
But he filed an application, separate application before the trial court to permit him to open the petrol.
Hmm.
That application was allowed.
Which is that writ petition? We will call this matter along with that writ petition.
Madam, your lordship may kindly dispose of this application. This is
No,
only-
that is an interlink between these two cases. It is in respect of the same suitable property. Now that, see, if I say you have a right, then it will bearing on that writ petition which is filed in that running the petrol.
Allah, writ petition is my lord, only my lord to, as far as an order in his favor, my lord, to run the petrol.
It is suitable property only.
Civil property only.
Which is that writ petition?
Order.
We'll call this matter along with that writ petition.
Your lordship may kindly, my lord, sir.
No, that
Lordship
here-
can dispose of this application independently, as your lordship rightly said. This is a appeal against an order of injunction, refusing injunction. The scope is very limited. Whether the said order is capricious or
No,
is
now
not in
that-
accordance with law. Now, can he file an application in the appeal seeking permission? Because your lordship is said this is a separate proceeding in a writ
No,
petition.
see, writ petition, when that case is pending before the writ petition, I can't say that run that now tomorrow. writ- interim order.
ಅಲ್ಲ
Therefore,
ಅವ್ರ
it's
ಪ್ರಕಾರ ಅವ್ರ ಪ್ರಕಾರನೇ
cannot be
ಪೆಟ್ರೋಲ್ ಹಾಕ್ಬೇಕಾದ್ರೆ OTP ಕೊಡ್ತಾರೆ.
No, that is
OTP ನನ್ನ ಹತ್ರ ಇದೆ. ಅವರೇ ಹೇಳ್ತಾರೆ ನಾನೇ ರನ್ ಮಾಡ್ತಾ ಇರೋದು.
see,
OTP
I won't want
ಬಂದದ್ದು
to-
ಜತನ
I
ಬೆಟ್ಟು
won't want to
mobile.
enter into that issue because it is already pending in that writ petition.
Yes.
If I say here no, then your writ petition is also, it will affect your rights.
Yes.
We'll call this matter along with that, which is that writ petition number. Learned counsel, the party submits that. There is a writ petition,
21647 of
21647.
Allah, my lord, your lordship may direct the writ petition to post.
That's what that. Office is directed to post this, office is directed to post that writ petition number
21647 of 22.
Yes.
2147 of
647.
Allah, learned counsel for the party submits that. Writ petition so and so is filed arising out of
Order on
One of-
IA number 21.
one of the suit scheduled properties. Hence, office is directed to post this writ petition number so and so along with this MFA. When do you want? Next week?
ನಾವು ಯಾವತ್ತು ರೆಡಿ.
Next week.
Next Monday. Next.
Next Monday. I don't know because they have to take a permission from the Chief Justice and we'll have it on Thursday.
Next
Other next
coming
Monday.
Monday.
Then fourth.
ಫೋರ್ತ್ ಎರಡು ಇದೆ 6th ಆಗ್ಬೋದು.
Sixth ರಜಾ ಇದೆಯಾ?
ಇಲ್ಲ ಅದೇ
ಅದೇನದು ಸಿಕ್ಸ್ತ್ ರಜಾನ ಏನ್ ರಜಾ? ಸೆವೆಂತ್
appellant.
Yes.
But the defendant is the appellant.
Yes.
The plaintiff before the trial court is my vendor.
Defendant is the appellant.
Yes.
Yes.
The plaintiff before the trial court is my vendor.
Yes.
So there was an agreement of sale
Yes.
in which it was agreed that after getting the lands bodied,
Yes.
the land will be conveyed. The responsibility of the body was on the plaintiff as per the terms of the registered agreement. The body was carried out. After the body was carried out, the executor said it in our favor by receiving about 14 crores and as the consideration. After having received the consideration, sale deed is executed, registered sale deed is executed in my favor. They did not immediately challenge the sale deed, but instead what they did, they challenged the body proceedings on the premise that one portion of the property which is indicated as a portion of the property covered in the sale deed is not our property. That is the contention which they are raising. So on that basis, the body proceedings was sought to be set aside, but that's a matter which is now pending before the Honorable Division Bench. With an interim order granted. Now, my lord, sir, the plaintiff files a suit saying that the sale deed is executed by means of misrepresentation. Therefore, they should not be permitted to alienate the property while challenging my sale deed.
No, that yes, challenging the sale deed declaration.
Now he's challenging. Kindly have a look at page number 53, what is stated by him.
53.
Yes,
Yes. Yes.
The contention of the plaintiff in the survey authorities conducted body work without following procedure without applying concern of this committee. Survey officials, including the land and owners in the body of disputed property. Now the defendant number one offered to sell the property in dispute to third parties. The defendant number one do the same, the plaintiff will put to inconvenience. Contention of the defendant number one is the sale executed by the plaintiff. Then the plaintiff do not have a right over the disputed property. Survey officials did the body work on the instigation of the plaintiff. In the interim order is granted, he will be put to inconvenience. In the instant case, disputed property originally belongs to the government land. Government passed circular in respect of disputed property. Even that the government officials conducted body work and prepared revenue documents in terms of the plaintiff and defendant number one, such being the circumstance. Before deciding the genuinity of the sale deed, sale deed genuineness is never brought in question. If the defendant number one alienates the property to third parties, it may be difficult to the plaintiffs to take back the property from the prospective purchaser. It may cause multiplication of the proceedings. If the plaintiff finds to succeed in the case, defendant number one will get the opportunity to sell the property in question. Value of the land will increase day by day. If the property in question will vary in future, it will not cause any hardship or inconvenience to defendant number one. That's what I would submit in circumstances like this. I would not say in a matter where a sale deed is under challenge and not well need is sought for. There should be just and reasonable grounds because the person who is challenging the sale deed is the person who is executing the sale deed itself. But in such circumstances, there cannot be an unconditional order. He has received a consideration of 14.5 crore.
Now, what is the prior in the suit?
It's the prayer in the suit for cancellation of the sale deed.
Cancellation of sale deed.
Yes, on the ground, that's what I read below at page 53. On the ground that a portion of the property covered under the body is not my property.
Yes. Now, is there any effort is made to alienating the property by your client?
Now, my submission is this: I don't want to alienate the property. Presently, is different aspect. Plaintiff cannot casually come before the court and say that there should be no part of condition.
It is sold by our consideration.
It is sold for a consideration. If he wants to seek for such a relief, that I should be restrained from exercising my rights under the sale deed. I should deposit the sale consideration before the court. You know, if you're not just to see the mandate notes under Order 39 or 39 Rule 2, or 39 Rule 2, Sub Rule 2.
That alienation is also subject to section 51 of the
Section 52, the moment section 52 is there, sale it in place. Now, my vendor wants to restrain me from exercising the rights which is derived under the sale deed.
Yes.
Order 39 Rule 2. The court may by order grant injunction on such terms as to the duration of the injunction, keeping on account, giving security or otherwise as the court thinks fit. It should be asked in order to deposit the entire sale consideration if he wants to pursue this suit.
Yes.
He is sitting pretty with my consideration of 14.5 crore rupees. He is restraining me from alienating the property. It cannot happen. He cannot have the cake and eat it too.
Yes. Issue notice. Dated 21st September 2022. Passed by Third Additional Senior Civil Judge, Bangalore, Rural District, Bangalore, is stayed till next day of hearing. Notice.
Appellant. Lord, my petition seeking revocation of grant of probate came to be dismissed. The copy may be served on standards.
Yes, it is dismissed.
It was dismissed.
Yes, notice is ordered.
No, ma'am.
Appearing as an cavator or notice is ordered.
No notice.
You are the only respondent.
Bill was granted, the alleged bill was made in 93. Keep quiet for 20 years. Just later in 2018, they seek for probate.
Now it is application is rejected.
My petition for seeking revocation has been dismissed.
Or revocation is dismissed. Now that when it is granted in favor of
2018.
2018.
Please, alleged bill was executed, was made in 92.
Now, why your application for revocation is rejected?
My lord, in 2015, I filed a suit, my lord, seeking declaration with respect to the same properties. The learned trial judge has said that since I can agitate my substantial rights before the trial court, the petition, the challenge may not be maintainable. The order is in page number 54. Sorry, the order is in page 13. Video dot.
Page 30, yes.
He's relied on
Declarations
judgment.
in respect of the item number so and so suit, the mother of the respondent was contesting the said case subsequently the woman is the so and so. You have filed a suit for declaration.
Please, and injunction. The respondent has been made party in that proceeding. Subsequently, they've initiated appropriate proceedings without making me a party.
The recent case that petitioner is the son of the second respondent. What is that finding of the trial court?
The suit is pending.
No. But what is the reason given for P&SC rejection of your application?
The trial court judge has relied on one citation.
What is that citation? To read that.
Page number 18.
Yes.
In light of the official legal position in the instant case, the petitioner is the son of the legal second respondent. Second respondent is the only daughter of the testator. Even in the absence of this will, the entire estate belonging to the testator would have devolved on the second respondent. The petitioner claims the property is covered under the will by way or a settlement deed dated 6/4/1990. It is on the basis of the said settlement deed, he contends that though the testator was the owner of these properties, by executing a memorandum of settlement in his favor, he ceases to tie the owner of this property, and therefore, even if he has executed the will in favor of the second respondent on 15/11/1989, the said will came into effect only on his death on 15/2/1991. As on that date, he has no subsisting right interest in any of these properties under the will. If the petitioner is able to establish his title to these properties under the settlement deed dated 6/4/1990, notwithstanding the grant of probate by this court, the second respondent would not get any right in these properties. Therefore, the title of the petitioner, if any, is in no way affected by these probate proceedings and the grant of probate. It is always open to him to file a suit for declaration of his title based on the said settlement deed. And in such proceedings,
you are claiming that there is a settlement deed in your favor.
no, my lord, I'm seeking declaration based on natural succession.
No, that.
This is just.
Then if you succeed, then there you have to.
No,
you have to prove that there is a will. By granting that will, yes, it will be the finality there, Mr. We are claiming that succession. But now that you are claiming a defense before that suit, saying that there is a will in your favor.
Yes, my lord. So will is there. So in
Now
that
that,
proceedings we'll prove it, my lord. In that proceedings we'll prove it, my lord.
Now, what is the effect of that taking a P&SC decree? Will it not come in the way of that trial court to give you that finding? Once you have taken a finding that there is a will in your favor, it has been proved. It is a substantial proof that I think there is a judgment you need not prove again. Is it not? What is the law on that point?
What has happened is in 2015, when I filed my suit, he's been made a party. Subsequently, without making me a party in his probate proceedings.
That is, you forget what the court said. All that can be agitated before the suit for declaration. Can it be done? What is the law on that point?
In this,
see whether in the suit for declaration, court can again go into that validity of the will. Can they go into that? If that is the law, then this judgment is correct. Because ultimately there it will be decided why this again revocation. What is the law on that point, Mr.? Once he has taken a succession certificate, it cannot be reversed in the declaration suit.
I seek instruction.
That is what that trial court held. Anyhow, declaration suit is there. There it will be decided. If that is the law, it is correct. Otherwise, law is otherwise than that, saying that no, once P&SC case will is been validated, it cannot be reversed. Then this judgment is wrong. That is what that you have to be.
But my contention, my lord, is that they kept quiet for 20 years, my lord. Only after I filed.
No, all that can be decided in the declaration.
No, what is happening is that based on this probate order, my lord, they're trying to seek a change of revenue entries.
No, all that can be seeking a injunction in the declaration suit.
All the contentions are open at that.
Now
and
you
submission.
first
Let them
answer
go
this.
there, my lord, so that.
Whether you can take in such a defense, even though there is he has a degree under that P&SC. You can do it, then everything is has to be done. What is that? Again, revocation order has to be passed.
But not all scheduled properties, my lord, that have been granted probate are made part of the declaration. So only one property we are seeking declaration. The other two properties which have been granted probate have not been made part of the proceedings.
Why you are not seek for a declaration in that other two property?
Those properties we seek for a declaration and consequential injunction. They have not interfered with those properties yet, which is why we are not.
No, you are claiming a declaration on the basis of what?
Natural succession.
Then she is also entitled.
She's not part of the family tree. She's a stranger.
Not your sister.
No, she's not my sister. She's a stranger.
Then even for one property also will has to be tested. If will is not proved, it's gone. If it is will is proved, then what is that the succession is issued is
These contentions are always open in that suit, my lord. They
Now,
can bring
only
everything
point
and they
is
can
that
get defense.
whether in spite of granting in a successful certificate, validity of the will can be gone into by the trial court in the declaration or not, we have to be satisfied. Then I will answer you. Then your problem will be solved. Yes, you just verify on that point. When do you want?
Weeks time.
Yes,
Till then, let them.
That is the law point, mister. You should be ready on that point. You are all youngsters. After court has to formulate that point, then you have to ask to get ready. You should. Trial court has dismissed only on the ground. You can agitate everything in the trial declaration. Is it the law or not? If it is not, that is not the law. You have to be argued and place the judgment. Then order is wrong. Yes.
Monday.
Tuesday. Yes. You also verify, mister. You also come up with the judgment saying that this is the law. Yes. Youngsters also not doing anything, mister. Yes.
Meanwhile, copy may be directed.
Copy kodi avrige, Mr. Counsel. Serve a copy to him. Appeal memo. Yes.
This matter is pertaining to section 85B of
85? Yes. Order passed under yes, code. 45A order has been passed. 85B. The damages for. Yes. Notice. Password.
And for the respondent, counsel is not taken. Yeah, Tuesday.
Yes, Mr.
Not made in a between my.
No, that two things. If you want adjournment, don't press the matter on the trial court. We'll undertake that. Yes. Leave this matter next week. It is there, counsel.
Because the amendment is permitted by the reported matter is remanded. Contrary to matter the judgment of the Honorable Court in the circular.
No, that MSA. No, that if MSA is allowed, that remand order is set aside. Even his amendment will also go. Nothing will happen.
Now,
No suit for.
declaration.
It is. No, he has filed an appeal.
Completely change the boundaries of the school property. Extent also will change. Now, the appellate court might allowed the application.
No, that both order has been passed in that. Yes, Mr. You are changing that entire this thing. Any other?
Only boundaries have been.
He is not
Kindly
the
after
council.
Tuesday, Rana.
Even if it is amended, nothing will happen, sir. If you set aside, everything will go.
Only boundaries ashtay.
Ade, our undertake. Don't do it, Mr.
Only boundaries ashtay.
Don't do that. Any amendment. Matter is you request the court saying that you have taken a time. Yes, use this matter. When do you want? Next Thursday. Yes. At the request of respondent.
Number 44, Narayanan MR for petitioner, Rajesh A.
No proposal for any settlement in this matter, my lord.
Hmm.
My lord, here the appellant being having lot of income, my lord. More than 34 lakhs income he is incurring by way of agriculture, my lord.
What is
Tangin
that?
tota ide, Mavin tota ide.
What is that order passed by the trial court? 15,000 per month.
Yes, my lord.
ಕೊಡ್ತಾ ಇದೀರಾ ಅದನ್ನ?
No, my lord.
No, that.
Intention is that we have a lot of land in the district. That is a co-parcel land.
ಆಯ್ತು ಅದ್ ಬಿಡಿ ಅದು ಐ ಆಮ್ ನಾಟ್ ಆನ್ ದಟ್ ಪಾಯಿಂಟ್. ವಾಟ್ ಇಸ್ ದಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್?
But till now we have been not.
Wait, madam, I am reading that project. See, have you paid all arrears? There is no arrears. No, this court said 7,500 from 12/4/2022. Till then, as per the family court order, you have to pay that arrears. No, that no, I will grant that. I will grant the time. You have to produce that all arrears, and as on today that you have paid that maintenance. If there is any due, it will be dismissed on that ground itself. Will not go on. Adu ee month bidi. All that arrears and that.
From the date of order, from the date of order of the trial, as per this court's order, 7,500 has been.
No, 7,500 from the date of No, that is not that. Petitioner is an agriculture. The impugn order is said subject to the condition that petitioner shall maintenance of rupees 7,500 to the respondent and clear that entire areas of maintenance from the date of petition till the date of making deposit, calculating the arrears 7,500 per month. Yes.
My lord,
Arrears shall be deposited before this court 7,500 per month from the date of petition till today. You have to be paid. There should not be any due. Yes.
My lord, since 12/4 they have not paid. Since 12/4 is the order, my lord. From that date till today, we have not received a rupee.
He is saying that he has paid.
My lord, 1,500, 2,000. This is how meagerly they are.
No, madam, court said 7,500.
Yes, my lord, it's not.
From the date, we can calculate what will come to how many months. If it is 7,500 in per month, if it is 36 months, what is the amount?
Yes,
if you
my
paid 500, 1,000, that can be added.
Yes, my
It can be calculated. It is in a mathematics.
My lord, that is my point, my lord. She is a desperate lady. She is
No.
bedridden, my lord.
To hear his case, let him comply this order first. Then we'll go to that other point.
Very short date, maybe.
Wednesday. By Wednesday, Thursday, you produce that all the document to show that interim order is complied. Then otherwise we'll dismiss it. Yes. You serve a copy to her also before that. Serve a copy to her. Yes. Next counsel for petitioner has filed in a memo stating that the matter has settled between the parties amicably out of the court. Hence, he will not press for the petition. But the matter has been settled between the parties amicably, sir. Hence, he will not press for this petition. Memo dated 24/8/2023 is taken on record. The above petition is dismissed as not. All pending applications are disposed.
Serial number 46, MB Maheshwara for petitioner.
Why? Notice. Notice. Yes, Mr. Yes, ಮಾಡಿದ್ದಾರೆ. Respondent is directed to pay 10,000 per month attendance from the date of petition till her life. Directed to ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ ನಿಮ್ಮರು? ಅದು 50% petty, yes. Or issue notice. Day of dated 19th November 2022. Passed by Family Court, Mysore, in criminal miscellaneous 63 of 2022. Subject to condition. The petitioner has to pay monthly maintenance to the respondent, 5,000 rupees per month. And he has to deposit that arrears in the rate of 5,000 from the date of petition till today before this court within 2 weeks from today, and he is directed to continue to pay monthly maintenance at the rate of 5,000. So the date of petition, that is what the trial court said. No, that I have reduced only 10,000 in the 5,000 money. All other things will applicable. Yes, issue emergent.
Number 48 is G1K. Number 48, G1K.
G1K.
Number 48, Chandrasekhara K.
Yes. Husband petition. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Yes. Yes. Issue notice. ಯಾರು ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್? ನೋಟಿಸ್ ಬೇಡ. ಯಾರ BJ Krishna is directed to take notice for restraint for this matter along with the sounds. Office is directed to secure original records from the family court.
Number 50, Rupesh B.
Have you taken the defense that she is voluntarily left the house? Put 135. Or so and so learned counsel appearing for the petitioner submits that specific defense taken by petitioner husband that wife has left the house voluntarily the petitioner has not deserted her. Trial court has not considered this aspect of the matter. It is sought for stay of impugn order in view of the above order dated 10th April 2023, passed by First Additional Principal Judge, Family Court, Mysore. The criminal miscellaneous number 824 of 2022 is stayed till next date of hearing.
And before the matter, serial number 51, Shekhar Badigar for appellant, PD Surana.
Yes,
ಬೆಳಿಗ್ಗೆ ರೀಚ್ ಆದ್ರೆ ಮಾಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ರೀಚ್ ಆಗಿದೆ.
No, that can you finish both of them? Can you finish by 1:30?
That
Monday, better. Next Thursday. Monday, I think I'm not sitting.
Very good.
Yes, Thursday. Yes.
Another matter, 54.
54. Yes, Thursday. Pre-order granted earlier is extended till next date of hearing.
Serial number 52, 53 adjourned. Serial number 54 adjourned. Serial number 55, Raghavendra A. Kulkarni for appellant, Abhinay Whitey.
Okay. Yes. Ready.
No, I have the file, I take the file.
Yes, give the copy to him. I will direct it to delete the name of Abhinav.
Please.
Yes. Office is directed to delete the name of YP Abhinav for respondent. Continue to show the name of H. Shanti Bhushan ASG. Yes. Use this matter next week. You serve a copy to him.
Serial number 56, Gita Devi for appellant, H. Bharata Sarathi.
Where is Parthasarathi? Yes. Password or next week. Yes. 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 None appear for the respondent. Leave this matter week after next.
That is the entry for appellant Krishna.
This matter is regarding the contribution paid and the levy of damages. The court has held that the levy of the damages, and has to be taken into consideration and then has, the matter or the claim.
No, so somebody has argued last time, your colleague.
My colleague has argued. that
Yes.
the Judgment on the Supreme Court may not have been followed.
Yes.
Wherein the matter,
Why it is urgent last occasion? Mr.
the morning Christian, he argued one admission matter, my lord,
Yes.
this morning. he put together. But the issue is under the PF Act. However, the ESA cases were following the HMT judgment. The HMT judgment has been overruled here.
Yes.
Therefore, what will be relevant may not is the question is whether non-payment of contribution which is statutorily imposed, not a due.
Yeah.
But a statute, civil liability is confronted him. So therefore, the element of penalty will not become a criminal matter. It is civil obligation to find the difference. Take your lordships to the paragraph 10.
Yes. Yes, Mr. Ready? That you give the brief facts then.
Please. Yes.
Yes, that is the conclusion.
Not there, not there. Not there. Not the respondent establishment is covered by the act. My lord.
Yes.
Under the act, that is not in dispute.
Yes.
My lord, there was a delay in payment of contribution.
What is the period? What's your name, Mr. You are Dhananjay?
Yes, my lord.
Oh, who is Krishna?
Wali.
Wali.
The wage period 2003 to 2007.
2003 to 7.
For the delay in payment of contribution.
Yes.
Belatedly paid.
Yes.
The date of payment is 2010. April and May 2010, they have made the payment. When they are actually the due date, according to the statutes, they have to pay with it. Month end, it is month end, August by September 15 days, they have to deposit the amount. Quarterly, they have to furnish the returns for having paid the payment.
Yes.
Now, when they do not pay the payment, then it attracts two things. One is that section 39 of the ESA Act. Is it? That I mean, that the legislation has taken this care
Yes.
to ensure that there is compliance in due time.
Yes.
Now, once he's an insured employee, is insured employee for his lifetime, even after he retires, at the age of 58, 60, they retire, or he demises, his family members, till their lifetime will be a dependence and we'll have to take care of them medically.
Then employer has to pay even after death of his
No
employer.
payment. Payment is only during his lifetime.
Yes.
So during his retirement, post that also he will get the benefit. Once an insured employee, his card is sufficient. He becomes an insured employee, it's a Pehchan card.
Yes.
Now we have an Aadhaar card, we have Pehchan card.
Yes.
That card is sufficient for him to get the treatment in his lifetime. He was an ex-employee, even he gets that. The obligations become mandatory for these reasons. Therefore, when they do not pay the contribution, then we will be levying the statutory interest in section 39 subclass 5.
Yes.
The contribution paid in fact is not paid with fiscal employer on the date on which the contribution will become due. He shall be liable to pay simple interest of 12% per annum. Higher rate as per the specific regulation. So the expression here is shall be liable.
Yes.
This becomes mandatory. Now he has paid the interest also. Now the ESA court says on the they have paid the principal amount of the interest, therefore the damages. I follow the HMT cases and there is no intention there. The
Now,
delay payment.
which is that provision applicable for damages?
85 P.
No, admittedly, there is a delay.
There is a delay.
Then they have paid that interest also.
Yes, they are paid.
Then they have admitted everything, whether damage is applicable or not.
Now, my lord, they say they pay, the court upholds payment of damage, but reduces. 3,00,000 more court ಬದಲಾಗಿ 10,000.
Why?
Why no reasons are assigned, my lord?
No, you show me that
85.
85B. Is there any power for reduction?
The circumstances which even the act itself says when it can be
Yes,
revised.
see that, yes. Which is the class you are reading? 85?
85B.
85B now. B. Yes.
85B for value.
85B. 85 capital B.
Please, my lord, please, my lord. Sorry, my lord. Capital B, my lord. 85 is.
No, is it newly?
Criminal for offense, yes, my lord. That also is
85B.
attractive. 85 capital B, my lord. You
85.
want to recover damages, my lord.
That I think it is a new provision. 85B. 85 is there. There is no B. Oh, it's maybe. Yes, 85B is there. Yes.
Yes, my lord.
Yes.
Please get them to give respect to any. I want to recover damage. This government of this act in relation to the industrial company in effect of human capital is sanctioned. Subject to such. Any damage recovered by land revenue, but the regulations 36 provide.
No, only situation where it can be reduced with the sick industry. There is no other option. Yes.
This case also it is a running under sick industry.
Let us see what is the reason given by that ESI code.
Regulation 31C.
Yes. 31C. Yes.
But not paid in time. If an employer pays to pay contribution. Any other amount paid in that. It is not exceeding rates, that is the rate has been specified.
Yes.
Less than 2 months, 5.
Yes, yes.
Now that contribution. What? And it can be reviewed. And how much 60% damages is paid, then it. In exception, artists made with the appropriate quality damage to the. The question is here again BIFR. BIFR situation is not a in case of changes of.
Allah, you don't be in exceptional odd cases. You are either totally or partially the damages levied or.
That is not here again. In case of change of management, BIFR is the management change now the subject of the late. That or the workers cost to be taken over. There are in case of merger.
No, that 31C.
Please, I come to that. 60% ಬರೋದು completely waived damages in such cases. Then in other cases, 60%. In exceptional hard case, what is an hard case? We have to look at it. Now, this is BIFR situation. Now, this case which all the courts were
Yes.
applying this, and that's how the HFD case came about.
Yes.
HFD case Supreme Court has held that following this, courts can waive the opinion. But however, this judgment will not well appreciating. PF Act, which is parametric, similar words are there even in PF Act. The Supreme Court has held in this judgment I need para 6, my lord.
Yes,
Just to understand the wordings are exactly
Yes.
similar.
yes.
So para 6 of judgment. 14(3) of 1952 Act was parametric 85(b) of 1948 Act of there is reduced. 85(b) of yes Act, my lord.
Yes.
That is the power to recover damages will imply make default in favor of pension fund or insurance fund or transfer that may authorize notification. May recover from employer by way of penalty such damages not exceeding as was specified in the key. What is before levy such damage default should be given. Damages. Then if it was been scheme. And establish section 6 of 6. This is exactly the similar what you use. I mean, that's what has been stated here also in the beginning of section 6 itself reads that way.
Yes.
Therefore, the question is now whether this now after this the question that arose here. Question paragraph 10 my lord.
Yes.
Question that emerges for our consideration in the instant appeal is what will be the effect of implementing breach of civil obligation as to whether the breach of civil obligation is or the element of mens rea actually is one of the essential elements according to play the parties of obligation to examine justification if any being tendered when passing order passing. So the question that was engaged the Honorable Supreme Court in this particular case. Now, I will call to in paragraph 12 and 13.
Yes.
Paragraph 12, they got a two-page judge of some court. For example, regulation that is mutual fund. Penalty to some defaults give mutual fund. Examine the person. Essentially, imposing penalty. They can go to find. Held at Wednesday on essentially reporting penalty for previous. That is what paragraph the judgment.
Yes.
The 33 to 35, mutual fund judgment has been taken into consideration.
Yes.
At the paragraph 35 has been called out.
Yes.
T.
Yes.
See now funds, various of the judgments have been referred, my lord.
Yes.
Where the paragraph 13, 14.
Yes.
At least half a dozen judgments where there are various statutes under which there is a levy of penalty has been examined by the Supreme Court in the Sri Lanka mutual fund case, which is reported in 2006, like 5.
Yes.
Probably the lordship because all the judgments are there.
Yes.
Now we watch paragraph 13.
Yes.
As soon as the constitution statutory obligation as confronted with act of regulation is established, that's all required is if there is statutory obligation, if you have reached then the penalty starts attractive. Because the intention of the parties committing such violation becomes more irrelevant. The breach of certain obligation is the tax penalty. The provision of the act is repeatedly attack the review of the doesn't mean the fact that the contradiction of the behavior is what is not. Further, that unless the language is scientific, can lead the presence of India. We have this is concerned that such violation is not. Nothing requires NCR of the two. And once the contradiction is available, the penalty is to follow. So if I say NCR sectional living, it will not there. The penalty will have to be levied. Please judge bench of this code, even if India was having textile processors, well, examine the scope of habit of section. There is not an essential element because it's penalty. Only the two judges the judgment of the end stop was the CIT. Right? The HMP case is followed Dilip and Stock's case. Now, this case has been overruled by Union of India was the this bench judgment. Approved the view expressed by the two judges bench of this court in Sri Lanka mutual fund case and in para 18 to 20 as follows. Environment textile. So therefore, the explanation appended in section in the IT Act So now they have upheld the question, my lord, that the explanation appended to section 21, to concealment or giving inaccurate. Judgment in Dilip Bench of case is not considered defect of 11 Act. If it inaccurate section 200, the expectation indicates that to provide for remedy for loss of revenue. The penalty and such person civil activity, willful concealment is not necessarily infinite for a civil activity as the case of the matter of prosecution under section 236C of IT Act. About being the position, the plea of rule 96 that the consequence we cannot sustain. Dilip Bench of case was not correctly described as a SEBI case, but the SEBI case is analyze the legal position. Answer the matter shall be now, taking note of the exposition of law on the subject, it's well settled that mens rea or actus reus is not essential element in the or damages for breach of civil obligation damages. The judgment on which the law process applies relies, that is ESA Corporation, the division bench, in ignorance of settled judicial precedent of which a detailed reference has been made when examining the scope of ambit of 85B of ESA Act. Its paragraph section 14B of 1952 Act, placing reliance on division bench, judgment of division bench of this court in Dilip Bench held that breach of civil obligation exists or actus reus is included for levy of damages and or the quantum thereof. It may be noticed that Dilip Bench which relies the HFT case has been overruled by this court in Indian and Indian. The ESA code cannot be a binding principle subject to assistance the appellate. Therefore, it has been overruled by this judgment. The judgment is so when a taking note of the bench judgment of this court in Union of India versus the Karnataka textile processor, the finding on us the view that default in payment of EPF on by the Karnataka Act section 14B of 1955 is not an essential element in imposing penalty damages. Coming to the judgment. Now, this is the law. This is now the latest law.
Yes.
Coming to judgment here with us. The entire argument was that there is no willful delay. There was no intention to non-compliance.
Yes.
And the provision of ATP is only recommendatory, it's not directly, and therefore it should be.
Only the reason for reduction is there is no intention to delay in payment.
And the HMT cases get relied upon.
Where is that?
They are stated here. Para 16. Of the trial court judgment. Considering overall aspect of the case, about the principal guidance of the Supreme Court, in the ESAC versus the HMT, I am the applicant. What is bona fide? It was not no index was paid. Therefore, he has to pay. He is not paid. Applicant is paid for. What is paid? He is not paid accordingly. Therefore, he is paid the amount, and no action should be taken. Authorized the case to sign on special slip on A1 dated 2008. It's also not made efforts to pay the accordingly when knocking the door of ESA. Therefore, considering all this aspect, I have to view the applicant is liable to pay damages, not as claimed according to episode. Damages ಕೊಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಏನ್ ಕಾರಣಕ್ಕೆ reduce ಮಾಡೋದು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. Now it's not as claimed, but what is the aspect which appeal to the court meant? How to reduce it to 10,000 rupees. On one hand, he says you want to have paid, he is not.
Now that everything is admitted that there is a delay in payment, he is entitled for damages. 3,33,305. If you want to reduce, what is the reason for reduction? Now that now,
That proposition does not stand in view of this
now that
judgment.
if you see that section,
PIFR.
now that in exceptional hard cases, waive either totally or partially the damages levied or leviable.
This is what the HMT case had held. HMT case had considered that aspect. Now this aspect will not even come into consideration.
No, HMT case is in that of if there is any mens rea.
Now,
No,
if it was very good delay.
no, if he has if there is a delay, even then, if you see that a company is not a sick company, but now that if totally it is lost in that this thing, under thus this is in hard in the case of this thing, the word they are used is exceptional hard cases. Exceptional hard cases means it is not in a sick industry. If it is a sick industry, it is exclusively covered. Other than that sick industry, if there is an exceptionally hard situation, then also it can be reduced. There may be an intention to delay. Even then, now that company is not in the position to pay that amount, if they are in the loss, then also that can be. That is what that section regulation says, is it not?
Regulation.
Yes.
If you look at section now or not, if that if you sort of keep the penal procedure, if you look at the Supreme Court judgment now, and all this issue will not even arise.
That your regulation become ineffective then.
All that where we can waive, if at all we can waive since it's a sick industry. What would be an exception beyond that man, beyond a sick industry? Now the company is not functioning and therefore I'm closing. If it closes, then liability will be to the date of closing.
Yes.
Otherwise, thereafter is no liability.
Now when you have passed an order for damages, at that time company is closed, or that there are no income. Under that situation also, that is what that clause says.
That situation did not arise in this case.
No, that has to be examined. That has not done. He has straight away said that there is no intention. Therefore, I am reducing. For that also, there is no reason.
Here also there is no case that this is what they have stated in the 85B order,
Yes.
that he stated contribution labor charge paid. Now he says that there is no delay as indicated in our notice, requested time to submit delay, but he did not submit anything. It is not his case that he approached to us.
No,
the letter,
no, that may be think there is no defense that we are not in the position to pay now. He has defended the case like that. There is no fault.
The reason given was intentional, there was no intentional or non-intentional. That's it. So now the question of looking at that exceptional hard case did not arise at all. Did not arise.
Why?
That is not their pleading.
That's what now the pleading is not there.
Pleading is not
Continue 230.
there. Very good.
They want to time next week. Ask.
58.
This kind other side.
Type ಬೇಕಂತ ಹೇಳಿದ್ರ? Yes, office is directed to delete the name of Angadi SV for the appellant. Continue to show the name of H. Shanti Bhushan ASG. Leave this matter next week. Copy ಕೊಡಿ. ನಿಮ್ದ appeal. ನಿಮ್ದ appeal copy you have to be collected from your counsel. ಆಯ್ತು ಅವ್ರ ಹತ್ರ ಈಗ ಲಾಯರ್ಸ್ ಎಲ್ಲ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ, ಅವ್ರ ಹತ್ರ ಕಾಪೀಸ್ ಕೊಡೋದಿಲ್ಲ. ಇದ್ರೆ ಕೊಡಿ. Okay. What has happened?
Along with WP 7-9 on this.
Interim order granted earlier is extended available. Next date of the same of the. Continue. Okay.
Okay, sir.
34 ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ. Yes, you want Monday. Yes, use this matter on Monday.
Number 57, entry for appellant, Krishna R.
Or if there is no defense, can you not like?
Years ago, very, very, what is there was a dispute regarding the quantity. There was the change.
ಹೌದು. Yes. Yes. They have to pay it voluntarily. If willful intention is also there or not, there is no excuse for that. Only extraordinary circumstances. No. Yes. Yes, that is. Yes. 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 In other cases, depending upon the merit, reduction of the damages up to 50% may be allowed. No, there is no such discussion regarding that exception. Provision was there. It is only in respect of menstrual. Yeah, that is true. No, Act itself has provided as per that regulation. Then it's a part of. Then it is not that. Yes. Yes, Mr. Yes. Yes. No, this is beyond that period or before that period. This is before that period. That's no like similar. Yes. That was that this thing. See the things which are beyond their control. If they are yes. Yes. Natural calamity. Yes. No, that he has to say that what is that correction? Yes. That was. No, that if you see that first class, it is then if the company is under winding up by the Companies Act. Next says that extraordinary other hardship. Because no, chick industries, it is covered. The industry which is similar to that chick industry, but it is not covered under the chick industry, they can be also reduced. That may be the intention. Yes. 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 No, that this judgment is has to go in view of only on that relying on that HMP case. Yes.
Yes, point in a detail for the 6 million. Yes, I've received your notice, causing damages 3,07,000 for period of 2003, 2007, and I think 45 dated 13/4/2000. Pay the damages for the following. There is no intentional delay for since the amounts levied was determined in the section 45A proceedings. against the payments of the outside party. The principal amount is not related to the omission. in the payment.
Yes, what you want to point out in this?
Malad, he is given a detailed reply in this regard. Malad. And also the applied under the applicant applied to waive the damages through the amnesty scheme. This scheme Malad is applied.
Which scheme?
Respect. Amnesty scheme.
Where, what is the?
Page number 14 of the input order. Correct, 10 minutes. To some and substance of the evidence, AW was the chief.
Some substances evidence.
Ready-made garments, TS inspector and respective establishment for the.
An amounts, but we are agreed by the. Before the authority.
10 minutes. Yes, inspector and respective establishment of 2003 to March 2005, between 2008 and 2000. And claims at but he has not agreed for the applicant appeared before the authority. That is passed in order claim is part of the. Thereafter, the applicant has paid the entire amount claimed by the.
No, that's all facts, Mr.
Evidence has been claimed as a given up of 3 lakh. The applicant applied to waive the damages to the bank attached to the made by the authority. It is put at claim the payment was not intentional. The damages was not payable on the date of the inspection. In some of the inspection given to A9 market. Correct. Only manner. His witnesses was cross-examined in the.
No, that is all that is not the point. Anyhow, madam, I will send it back that they are relied only on that. HMT case, there is no finding. Let them reconsider. He wants to raise any points, they let him raise. Now that whether he is covered under that extraordinary, no, is it?
Para 16 years.
Yes.
Para 16 minutes. Now considering all overall the aspects of.
Yeah, no, overall aspect, the facts has been extracted. Then he said overall aspects, guidelines issued that guidelines is not applicable to your case now.
I am of the opinion.
Now they let them apply their mind without applying that HMT case and pass an order.
One of it, and there is no intention to get passed by.
No, he is asking only that. Yes.
However, the applicant has to pay the contribution, contribution for a period of. He has not paid the contribution. However, the order section 45A came to pass with the inspection report of the ESA officer dated 4/3/2008. ESA officer has also not claimed the contribution for the period of 2 years, and he kept quiet for 2008 to 4/3/2008. No action has taken. The applicant of the authorized signature sign observation of this dated so and so. He has also not made any effort to pay contribution.
No, even you are giving the clue also is not establishing and improving this case on that ground. Yes, but there is a, but whether this case is coming under that or not, estimate. Yes. Yes, Mr. Dhananjay.
Not claimed, my lord. Yes,
Not claimed the law. Everything is against you only. Only except order portion of that judgment. Like the second decision to thoughts it is covered. Where is that document to show that it is unsecured? There. There is no this thing. ಆ ನೀವು ನಾವು ಕ್ಲೂ ಕೊಟ್ಟ ಮೇಲೂ ನೀವು ಎಲ್ಲಾದ್ರೂ ಆ ಪಾಯಿಂಟ್ ರೈಸ್ ಮಾಡಿದೀರಾ ಎಲ್ಲಾರು ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅದ್ರ ಮೇಲ್ಗಡೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಾ ಅಂತ ನಾನು ನೋಡಿದ್ರೆ ಯುವರ್
ಹಾಕಿದ್ದಾರೆ ಅಸಿಸ್ಟೆಂಟ್ ನಲ್ಲಿ.
ವಾಟ್ ಇಸ್ ದಟ್ ಇಂಡಸ್ಟ್ರಿ ನಾವು ಇಸ್ ಇಟ್ no, what is this industry, madam? What is that now they are doing?
Ready-made.
Huh? Are they running now? They are paying that this thing now for the contribution is. ಆಯ್ತ್ರಿ ನೀವು ಅವಾಗ ಆ ಡಿಫೆನ್ಸ್ ತಗೊಂಡು ನಮ್ಮ ಲಾಸ್ ನಡೀತಾ ಇದೆ ಕಂಪನಿ ಏನೋ ಇಟ್ ಈಸ್ ಅಬೌಟ್ ಟು ಕ್ಲೋಸ್ ಆರ್ ಥಿಕ್ ಇಂಡಸ್ಟ್ರಿ ಆಗುತ್ತೆ ಅಂತ ಆತರ ಡಿಫೆನ್ಸ್ ಎಲ್ಲ ಇದೆಯಾ ಅಂತ ನೋಡಿ ಅಂತ ಬಟ್ ಯು ಆರ್ ನಾಟ್ ಆರ್ಗಿಂಗ್ ಆನ್ ದಟ್ ಪಾಯಿಂಟ್.
A6 ನಲ್ಲಿ
ನೌ ಐ ಆಮ್ ಜಸ್ಟ್ ಸೀಯಿಂಗ್ ದಟ್ ವೆದರ್ ಇಫ್ ದ ಕಂಪನಿ ಇಸ್ ಏನೋ ರನ್ನಿಂಗ್ ಪ್ರಾಫಿಟಬಲಿ ಐ ಕ್ಯಾನ್ ಕನ್ಫರ್ಮ್. Yes, what is that contribution they are paying? Whether they are capable of paying that 3 lakhs or they have to close because of my order. Huh? Export government. Yes. NKG Enterprises. NJK Enterprises.
Discretionary powers exercised by the learned.
He has to exercise the power within the framework of the law. We even High Court also. This is not 226 proceedings. Yes, currently. No, these damages will further will not carry any interest. No, it is only that. Yes. Reduce ಮಾಡಕ್ ಪವರ್ ಇಲ್ಲ ಅಂತಾನೆ. Then there should be a reason for that. Yes, third. This appeal is filed by ESI Corporation. Section 82, subclass 2 of ESI Act 1984, 1948, challenging order dated 31st January 2017, passed by ESI Court in ESI application number 29 of 2012. Thereby, damages claimed by ESI Corporation of rupees 3,33,305 has been reduced to 10,000. Three facts of the case are that respondent establishment are engaged in manufacturing of ready-made garments and having their factory at the they have a ready-made garments and establishment is covered under ESI Act. The ESI inspector inspected the records of that company for the period January 2003 to March 2007. Between 28 to 2008 to 4/3/2008. Submitted in a report claiming certain amounts from the applicant. Since the applicant, that respondent establishment didn't agree the claim, show cause notice was issued to the respondent on 19/7/2008. Respondent establishment appeared before the inquiry authority. After peruse the records, inquiry authority has passed an order on 13/4/2010 claiming an amount of 8,52,082 rupees as a contribution against an amount of rupees 1,24,12,647. Thereafter, the respondent has paid the said amount on 30th/4/2010 and 15/5/2010 respectively. Since there is a delay in payment, corporation has issued notice claiming an interest and a damages of sum of rupees 3,67,615. Respect of interest is concerned, the respondent has paid. In respect of damages of rupees 3,33,305, the applicant has approached ESI court in application number ESI application number 29 of 2012. ESI court by impugn order reduced the damages of rupees 3,33,305 to 10,000 by impugn order. Being agreed by the same, ESI Corporation has filed this appeal. So and so learned counsel appearing for the corporation has submitted that there is no dispute that respondent establishment is not paid the contribution. It is also not in dispute that after the claim has been made by that corporation, they have paid that contribution and also interest. since they have intentionally delayed in paying that contribution, which is the section for damages. Section 85, capital B of that act provided for imposing the damages, for collection of the damages. Recovering the damages. She further contended that the ESI court has given a clear finding that respondent establishment is liable to pay the damages as claimed by corporation, but without giving any reason. The amount has been reduced to 10,000 by impugn order. Hence, the same is contrary to section 85B of the Act. She further contended that only reason given by ESI court that in view of judgment of apex court in case of Employee State Insurance Corporation versus HMT Limited and others reported in 2008 3 SCC 35. She contended that said judgment has been overruled by apex court in horticulture experiment station Koppal versus Regional Provident Fund Organization 2022 4 SCC 516. Hence, she contended that since the respondent establishment is not a sick industry, there cannot be any ground for reduction of damages imposed by the corporation. Once it is admitted that there is a delay in payment of contribution, the respondent is liable to pay the damages. Hence, he sought for allowing that appeal. For contra, the Dhananjay Learned Council appearing for respondent establishment has contended that there was no any intention in delay in payment of contribution. Since there is a error in calculation in the notice for demand of payment, therefore, there is a delay of payment. He further contended that the respondent establishment is under loss. They are not in the position to pay the damages since they have paid the contribution and that interest.
They are also applied for the amnesty.
Huh?
Amnesty scheme. This para 11, 15 million.
Not in the, they are in the loss. Hence, they are entitled for Berthin Ray. They are entitled for reduction of damages under that. It is that regulation. No. Where is that regulation? Which, I agree. Wait, Mr. Wait. Under 31C of Employee State Insurance General Regulation 1950. He further contended that the establishment, where is that? What is the scheme?
15 minutes.
Yes. Yes, they have also filed an application claiming a refund of 50% of the damages already paid in view of amnesty. What is the scheme? Yes. Yes. Yes.
Scheme is also provides for the benefit.
Yes. No, that has been rejected. That has been, yes. Hence, he sought for, considering all these aspects and also considering the judgment of Apex Court in case of HMT Limited Supra. The ESI court has rightly reduced the damages from 3,33,305 to 10,000. Hence, he sought for dismissal of the.
Para 16 and last.
Yes.
Yes, officer has also not claimed it.
Not claimed that contribution for a period of 2 years and kept quiet. That is what that they need not claim. It is you have to pay voluntarily. That is what the scheme is, Mr. Heard the learned counsel for the parties. Peruse. If you order and original records. It is not in dispute. The respondent establishment are engaged in manufacturing of ready-made garments. And also covered under ESI Act. The ESI inspector has inspected the establishment for the period, has inspected and inspected the records of the establishment for the period January 2003 to March 2007, between 28 to 2008 to 4/3/2008. Since there is a due in payment of contribution, after conducting an inquiry, the order has been passed on 13/4/2010, claiming an amount of rupees 8,52,082 rupees as a contribution, as against an amount of rupees 1,24,12,647, which was originally claimed by the respondent. Thereafter, the respondent has paid the contribution amount. The corporation has issued a notice. Corporation has issued after receiving that principal amount, corporation has issued two notices claiming interest and damages. Interest of rupees 3,67,615. Claiming interest of sum of rupees and interest is how much? Yes, claiming an interest of rupees 1,76,455 and damages of rupees 3,33,305. Without any dispute, the respondent has paid that contribution as well as interest. But damages is concerned, he has approached ESI court by filing an application under section 75 of the ESI Act. ESI court had a review order after considering that documents produced by the parties and after considering the evidence of the parties has given a clear finding that there is a delay in payment of contribution. The interest has been rightly levied, and also given a finding that damages awarded by 3,33,305 is just and reasonable. Only on the basis of judgment of Apex Court in case of HMT Limited, the amount has been reduced to 10,000. In fact, judgment of Apex Court in case of HMT Limited has been held per incuriam and overruled by Apex Court in judgment of Horticulture Experiment Station Vanikapalpur Supra. Therefore, defense claimed by the respondent that there is no intention in delaying paying that contribution is not available. Since there is a clear finding that there is a delay in payment of contribution, there is no any other ground has been urged. There is no delay. There is a delay in payment of contribution. The corporation is right in imposing the damages. The another ground which has been raised by the respondent that the ESI officer has not claimed the contribution for a period of 2 years, kept quiet for 4/3/2008 to 13/4/2008, and no action has been taken against the applicant establishment is concerned. Under the scheme of the Act, Section 39. Section 39 of the, under the scheme of the Act, as per Section 39, the contribution payable under this Act by the establishment, it is a voluntary act. There need not be any demand. In spite of there is a statutory duty, the establishment has failed to pay that contribution. After inspection, the authority has come to know that they have not paid that contribution. The order has been passed under Section 45A of the Act. Therefore, the respondent cannot be a claim any benefit under delay in demanding that amount. Except this, there is no other ground urged for reduction of damages. Therefore, the order passed by ESI court dated 31 January 2017 is without application of mine, contrary to the provisions of Section 39, 85B of the Act. Hence, the impugn order is unsustainable. Accordingly, order dated so and so is set aside. ದುಡ್ಡು ಕಟ್ಟಿದಾರ ಅವರು ಅಷ್ಟು ಮುಗಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಅದನ್ನ ಇಫ್ ದೇ ಆಲ್ರೆಡಿ ಪೇಯ್ಡ್ ದಟ್ ಅಮೌಂಟ್
ಅಲ್ಲ ಇಂಪ್ಯೂಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದೆ
ಕೊಟ್ಟಿದ್ದೀರಾ ದೆನ್ ಬಿಡಿ ದೆನ್ ದೇರ್ ಇಸ್ ನೋ ಪ್ರಾಬ್ಲಮ್ yes there is no any difference, mister. There is no any difference. See, maybe ಅವಾಗ ನಿಮಗೆ HMT ಕೇಸ್ ಇತ್ತು ಹಂಗಾಗಿ ಈಸಿಯಾಗಿ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ. There is no intention in payment of delay in paying that. Now that is also not available. Yes. Yes, password. Password
matter. Number 1. Serial number 6. P. Gangadhar for appellant.
None appears as a last chance. Speaks to verify ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಮುಗ್ದೋಗಿದೆ ಸರ್ ಕೇಸ ಮುಗ್ದೋಗಿದೆ. As for that information available in the records shows that suit before the trial court itself has been disposed of. ಯಾವತ್ತು ಎರಡು ಮೂರು 2020 on 12/3/2020. Hence, this appeal will not survive for consideration. Accordingly, the appeal is dismissed having been.
Happy for appellant. Number 9.
Each time is granted to do the needful.
Number 11, neither CH nor appellant.
No, appeal is maintainable. Your prayer is not correct. You have to seek for an what is that order? IA filed by the petitioner under Section Limitation Act is dismissed. Now that order itself is not properly see by dismissing that limitation, your application miscellaneous petition itself has been. That has to be in that order. Order is no you. Yes, I saw that order. What is that prayer you have sought? Set aside that order passed by that. So, in dismissing the interlocutory application filed by petition, seeking condonation of delay, consequently dismissing the said the entire proceedings. Yes, you have said the entire proceedings. Yes. Submission of learned counsel for the appellant is accepted. Office objection is that is the only office objection. What is this matter, Mr.? Now that what has happened to the suit? Suit for declaration. Suit is decreed. Yes. Yes. No, you just give that what has happened to that appeal. Amal
Proceeded further. But I could not be present on the date of immediate.
No, your suit has been dismissed.
I could have been dismissed after demand
Yes.
or non-prosecution. And I filed necessary applications to consideration of date.
Yes, now you take notice. There is no question of any stay. Because you are saying now that you take notice. Yes. Notice.
Number 14, whether A or appellant issue Sunday.
Council submission regarding to that office objection. What is this? No, what is that dispute between that scheduled and that difference between the scheduled and the yes.
The defendant is claiming the particular schedule is according to the saving investment of this thing, this is very disorder. Therefore, copy the price and objection given in the schedule because they actually dealt with the private client.
Yes, what is this matter?
Certain lands were subject to preliminary notification on 3/1/1985.
Yes.
Final notification was issued on 23/9/86.
Yes.
Award was passed on 25/9/86.
Yes.
Section 62 notification was issued on 12/15/1991.
Yes.
So that's what handed over to a society called as API.
Yes.
Cooperative society.
Yes.
But the acquisition proceedings came to be challenged.
Yes.
It was claimed that there was another layout which was already different during the pendency of the proceedings. Because between the time of the acquisition and the layout formation, people appear to have formed the layout. So that is largely on the residents association, they were the Even bench did not accept the challenge to the acquisition proceedings. Acquisition proceedings therefore became final. The society appears to have filed a memo in that interview stating that wherever there are existing constructions made by the members of the Sharpana Residents Association, we take possession. By recording this, the interview came to this post. So this is the actual fact. Then the society has sold the property in favor of LC Vasulas. It is secret. It also appears that the society has already filed a suit seeking relief from possession as against one this PV. It is Avia.
Yeah.
Just one minute. The native people value.
Yes.
The This is point number one, taken to the right.
Yes.
Now, in that. So, when the suit was pending, this in-case society has sold the property to the NC was given. When the property is sold, it is going to be taken.
Yes.
NC was given, if one sells the property, the is complete.
Yes.
It's not paying for that.
Yes.
But the safety, executed rate API for the second respondent, that is,
Suraj.
Suraj is on 7/20/21.
Yes.
And Suraj sells it to present cabinet Vijay Prakash 4/20/20.
Yes.
This Vijay Prakash sells it in favor of Srimati Kavita on 24/5/23.
54/5. Yes.
Now, with these facts in the background, the plaintiff approaches the court. Pursuant to court injunction simpliciter.
Who is the plaintiff?
Plaintiff is a person who claims to be a purchaser or a successor interest to the property which was held by the Shantivana Residents Association.
Yes.
The residents of that area. But nonetheless, their rights are only limited to the next. Then an injunction suit simpliciter is filed. What is the plaintiff has to look at the claim. Page number 51.
Yes.
But the relevant portion for your consideration will be paragraph number 11 at page 58.
Yes.
In order to achieve that purpose of dispossessing the plaintiff of the scheduled property, right to commit trespass over the scheduled property on 22/2022. With the help of Buddha elements and parents, but illegally trying to trespass on the scheduled property, and not the experts, demolished the existing 6 square building high-handedly with the help of JCB where number so and so. Even in trying to commit trespass, the plaintiff was away, and as soon as she got the news, she sent her son and reached the spot and so on. So by that time, demolition work was expected, part of the demolition was already done. Some of the plaintiff questions objected for the illegal interference. Defendant want the serious consequences, so on and so forth. I am not taking it. The paragraph number 1 is again stated that plaintiff submit that she is the rightful owner and considering possession of the aforementioned property, the possession of the property cannot. Whatever the nature of the rights of the different stakeholders of the scheduled property, they are not entitled to interfere in the possession. In the enjoyment of the plaintiff for the suit property, essentially knows what has been stated by the so factor is, and though it was claimed that there existing structure, as a matter of fact, the statement by the present apprentice that he was the one who after the purchasing of the property and built up a compound under shed. It was subsequently demolished after the purchasing phase. Now, if acquisition is confirmed, they don't have right to come. Their rights were restricted to disposition in accordance with them. That is the memo was filed by 88.
Yes.
According to them, there is already a disposition clause. The first question is whether the scope of the present is to have been. Either they could have filed a condition or they could have filed a section 6.
No, this disposition they said before filing the suit.
Disposition is taken place the moment it takes place before the suit.
No, that means before filing the suit.
Yes.
That is there. It is in the plain.
It's in the plain that the disposition is taken place, the demolition takes place. Now, as things stood when the suit was filed, it was a vacant piece of property where there was no construction standing. And there was no entry model granted in there, there were expert entry models not granted. The same had taken place, the construction was commenced by the subsequent purchaser, Kavita. Is at this juncture, the photographs were produced before the trial, saying that the construction is coming up. But now your assistant kindly see, but the landlord saying that since the construction is coming up, and give it appropriate to issue model.
Yes.
Operating portion of the order.
Yes. Just restraining from interference.
Nice. As things stand, the Intention can be granted against the right to know. The law as it tells you that even a trespasser is entitled to maintain a suit for intention in case of restitution. But a person is a right to know, there is no question of kind of that is a development law. They don't have right to know. That's a question of the intention.
Now that their only defense is before this court, they after evicting them only the society can allotment, they can do it. But in the case the plaintiff, they said they have been already demolished. The second thing is now that all these issues before the trial court, have you taken the plan approval and
Sanction of road is taken.
yes, madam.
Challenge and order. If he says he has sold the property pending, he has no regards, my lord, to the proceedings pending to the honorable court. My lord, the suit is filed in the year 2022.
Yes.
OS 1564 of 2022.
Yes.
Kindly see the same, my lord, 24/5/2023. 24/5/2023. After the suit is filed.
24/5.
After the suit is
Yes,
filed.
that is this Ganga. Who is that? Ganga is the appellant.
Yes.
Yes. It's now who is Kavita? Yes. Now that she has purchased that, she is also. She has not been implemented subsequently. Then why she wants to challenge? Why you want to challenge that order letter? If she, that is not that issue before this. Now that this appellant, he has already alienated the property. What is his right to challenge?
Obligation under the sale to ensure that this whatever they are issued under the sale is protected for the purchaser. This is has taken the view that cause of action is not passed upon sale. As a matter of fact, it is his obligation to continue in the proceedings because he has for sure to see to it that whatever is the obligations of the sale is fulfilled.
Yes.
That's the due date. If you have a continuous cause of action, till such time it is a valid continuous.
He continues to have the right. Not where did his vendor get the title and possession the lordship must look into it. We have filed a memo.
No, by continuing that suit, losing the title will not be arisen.
He will not lordships may kindly take the memo.
Yes.
Which I have filed. And what was it, what the state council said was a challenge to the acquisition proceedings is not correct. It is not a challenge to the acquisition proceedings. A layout plan is submitted by the PDA. By the society to the PDA, India society to PDA. The PDA did not approve the layout plan. So the PDA went on a petition before this honorable. Certain orders and directions of passed by this honorable court. Challenging that, an appeal was filed by the PDA and Shantivana Association. Kindly see, because we have a memo that is filed on 23/8/2020.
Where is that? It is
We have filed it.
your objection.
We not filed objection, we just filed it. Page 7. I have one copy in the past.
No, it may be there. We'll see.
Here is the order. Petition bench, page 38. Your lordships may see the new color marking at page 38.
Yes.
This is filed by Resident Shantivana Residents Association.
Yes.
That is 1332 of 2008.
Yes.
The other petitions are filed, other appeals are filed by BB and other parties.
Yes.
Your lordships may go to page 63 in page 28. Why the appeal came to be filed?
Wait. Yes.
Second line from top.
Yes.
On 26/3/2009, the Learning Council of the Society
Yes.
undertook to file additional memo with the affidavit to clarify the memo dated so stating that the apprehension in the mind of the applicant, the WA so that pursuant to the order imbued in this appeal, demolition of the structures and taking possession of the properties which are claimed by the members of the association will not be done without due process of law. Also for the submitted that apprehension of PDA that alternated land that is not necessary for us. I request your lordship to go to page 38 directly. Page 38, page 73.
Yes.
Affidavits filed by the society is taken on record.
Yes.
This order and direction passed with the division bench. Accordingly, Principal numbers 1332 of 2008 and the other one, they are disposed of in terms of the undertaking given by the society. PDA shall comply with the directions of the learned single judge, except the one which is expunged within the period of 1 month from the date of the society executing the activity. That is not necessary for us. NTI Housing Society is directed not to either demolish any constructions put up by the members of the Shantivana Residents Association or to evict any members of the association, the appellant will also, except in the due process of law, as per the undertaking given by NTI Housing Society, applications filed and so. Your lordships may note the order passed with division bench is dated 22/9/2009. The society keeps quiet for a reasonable period of time. The next page, my lords, page 76. It files a suit for possession,
Yes.
impeding the respondent here, the vendor. The suit, my lords, is filed for possession. The lordships may see the schedule to the suit. The suit is 25/9/2003 of 2018.
Yes.
Page 89, in page 14 of the suit.
Yes.
The schedule. All the piece and parcel of residential house. Now the appellant is stating that there was no construction. The suit filed by their own vendor said that it was a residential house. Page 14, in page 14, the lordships got me up. Page 89.
Yes.
The lordships got a schedule.
Yes.
All the piece and part of the residential house bearing number 6 so found in acquired land so east to west so north to west south so. Here, if I request the lordships to look into their own arguments, the argument made by the vendor of the appellant at paragraph number 12, page 83.
Yes.
Page 11, para 11, para 10, 11, all the appeals that were filed and all are stated. 83, page para 12,
Yes.
it is submitted that the illegal occupiers of the acquired land, the lordship got it, my lords?
Yes.
Fifth line.
Yes.
Of the acquired land of the housing society are educated and powerful persons who are also registered as an association known as Champions Residents Association to protect their illegal possession, fight collectively against the plaintiff society. This association is an illegal association of lawless persons who have committed criminal acts of trespass and fabricated and concocted documents to grab the land of the plaintiff housing society. Para 12, that this villain is one such person who has committed an act of trespass and constructed an unauthorized construction in the property
bearing carta number so and so, which belonged to the plaintiff housing society. By unequivocal terms, they say that there was a construction. They file a suit for possession.
See, there is no dispute that you have constructed. There is a clear direction dispute that you cannot be evicted from this person. See, what has happened to this suit?
This suit is still pending. My lords may go to the next document.
No, suppose
Page 2 or
even
page
after
119.
all this order, if you have been
My lord, we kindly see page 119, annexure J1. This is an order from AN 2, which was filed by us against NGI society. That's page 119 or 39 in 2002.
Yes.
In the suit filed by the society,
Yes.
we filed an order of injunction.
Yes.
Kindly see the observation of the court below. Page 126. Paragraph members.
Yes.
The learning counsel for the defendants has argued that the plaintiff society has filed several suits against different side owners and in respect of persons who do not enter into compromise with the plaintiff society. The plaintiff society is illegally selling the property in favor of its own members only in order to make legal gain from the side owners and also to extract money from the defendants and other side owners. Admittedly, the suit has been filed by the plaintiff for possession and permanent injunction in respect of the suitable property. But plaintiffs, in the objection statement, they've already sold the property in favor of one HC Basaraju. That too, in the year 2021, with the pendency of the suit. When a suit for possession is pending, what title or what position can flow to the applicant is a question we ask. The society has filed a suit for possession. There is an order of injunction operating against it. In that time, they executed CID in favor of its members. That too, my lords, violating the direction of the division bench of this honorable court, which clearly says that the members cannot be evicted without due process of law, and no demolitions can be taken place. So, first submission, my lords, no valid title flew to the applicant from the society. Since the society's suit for possession is still pending, to show that it is still pending, we have produced the order.
What is that order passed? IA and so on. When it is order has been passed?
119, 2nd July 2022.
2nd July?
2022. 119.
When that suit has been filed by you?
We have filed the suit March 22.
Now that after you are obtaining that injunction order, if they are demolished, why can't you?
Can I read it the plaintiff? Can I read it the plaintiff? This is not a complete demolition. A part of the building is demolished.
Yes.
Still, the resilient council, right?
Yes.
Defendants, in order to achieve their purpose of dispossessing the plaintiff to the scheduled property, I to commit trespass over the scheduled property. We have not admitted them trespassing. On 20/2/2020, the defendants, with the help of indictments, their henchmen illegally tried to trespass into the scheduled property and demolish the existing 6-square building. I handed with the help of JCB sponsor. When the defendants had tried to commit trespass, the plaintiff was away, and as soon as she got the news, she sent it back and he reached the spot at so and so. By that time, part of the demolition were of the structure and part of the building demolition was done. This is what we say.
Now, anybody has a present picture of that property?
Yeah, produce a photograph. There is no structure, it was standing on the pavement.
The question would be.
No, that I will understand.
Be permitted to continue the illegality which is vendor have done. The vendor, my lords, gives an unequivocal undertaking before this honorable court. This honorable court directs, my lord. What kind of title would his vendor?
I'm not on that merit.
Yes.
you may succeed in this case.
Yes.
It is only for the temporary injunction.
Yes.
Whether before filing the suit you have been disposed, whether you are in that possession or not.
They are in possession.
Now that what is the easy tennis? As on today, it is a vacant site.
It is not. There are certain constructions being put up.
Who has put up that construction?
That's possibly the appellant along with
Then you have been dispossessed.
we would not accept this position. But it is for the trial court to say whether we are dispossessed or not. Milord, it is an act
No,
of
no.
continuous principle.
No, that
Milord,
See, there are two things.
Milord, a person claiming illegal possession cannot be allowed to continue with illegal possession, Milord. That is what we are submitting before this honorable court. The vendor himself is in a suit for possession. He did not get possession. Could a person say, I have illegally taken possession, I will continue to put up construction. That is why the trial court said, let all things stay as they are till the suit is disposed. Now let's scan a person.
That's why I'm asking. Trial court has not said as things as stood as on today. They said they have been, if their status quo is to be maintained.
Let status quo be maintained, Lord. Let the trial continue. Let status quo be maintained. We are not asking for an injunction. Let status quo be maintained as on today. Can a person who seeks an umbrella, who is holding an umbrella, of an illegal act and that to a violation of a direction and an undertaking?
No, you are not, I'm not deciding. It is not that on the final judgment and degree. There we can decide now that it is only for the injunction. Even suppose if you are admitting that illegally they have occupied that possession before filing the suit. One more remedy is to possession.
As first, they vendor has to succeed in his position.
No, that is different. I'm not on that case. No, don't mix up. No, that is true. You can 100% you can win the case. See, if you see that possession, if you are filing the suit, before filing the suit, you are not in the possession. That is a discussion. No, that's what that. If suppose I'm asking that if it is a clear case of that plaintiff that I'm not in the possession, they can't even then that if it is a trespasser, you can't claim a suit for injunction. The remedy is for possession. Then I think somewhere some senior counsel has given the judgment I have placed before me saying that even at the time of filing the suit, if somebody has been dispossessed, interim order can be passed to status quo ante. That is not the order which has been passed here also. Now that present situation, you maintain status quo, you will direct the trial court to dispose of the suit as a, because
assume the situation for me. It is too during the course of whatever has been said in the previous. Okay, we can give the boss. In nature of the cases, let's say it's a viewers, the case will not be completed. The basis on which these two giving this such a ultimately when it comes to an unvacant property. Now we have all lines that need not be stated so far as an urban vacant property is concerned, because as things stood as of the date of filing of the suit, it was a vacant piece of property. That is what they have stated in the complaint. And whatever construction which according to that which they had put up was in existence as it is that there is nothing in it. The urban vacant property follows time. That's a law. Now, as things stands, the law is to see the division bench order itself. It says that acquisition is not challenged. It is an admitted fact that this is all the actual plans. Section 62 notification is in place.
but to see the direction of the division bench.
The direction of the division bench, I think that he should not. Injection cannot be filed. But there is no question of an improper remedy being sought for in the wrong remedy.
But your vendor has filed in a suit. That shows that they are in the position he wants to comply the division bench order.
Nothing more can be ready to it. So the right to the property is concerned, there is no question of anybody coming and questioning my title. Otherwise, the kind of observations made by the division bench would not have been made. It was a leverage given, or it was a lenience given, saying that all it will take possession will not have. The title was never in dispute because it's not acquired portions of property. Now, when the suit for injunction is filed, if they come to the court with a proper remedy, then it's a different matter. But when a suit for injunction is filed, assuming it's taken to a logical conclusion at the end of the trial, what is that they are going to get if this it's a disclosure that they are not in possession of the property as on the date of filing of the suit?
That is not the clear wording that they are not in the position.
You may have looked at the complaint, the complaint says, first it's the last.
See, the intention is after they are obtaining that injunction in that other suit, you are not a party, you try to interfere, they have filed in a suit. It is overcoming that injunction order, your vendor has sold the property.
That this order of injunction was granted, knowing that the person who is claiming to the property is not the person against whom injunction is being granted. I can understand, I read that order also right now. That order specifically says the person against whom the injunction is being granted is presently not the owner of the property. He is not in any manner concerned with the property. Therefore, I am granting an order of injunction. The order of injunction has been granted in the I number 2. It is now being read out. The order is important. It's at page number 127.
27 in that their this thing.
Yes, that memo. Page 127. Internal page 9 of the order passing notice number 2 of 18.
Yes.
Admitted the suit filed by the plaintiff of possession complaint against the respect of suit property. As signed by the plaintiff society that the objection stated that all the suit property first have to prove that the suit is identical. On the other hand, the defendants have made up accounts to show that the plaintiff is inferior in the different portion required for suit property. Admission regarding sale of scheduled property income of another person to show that in the application is not allowed.
No, that you forget about all these things. It is admitted by your vendor, they are in the position by filing the suit in the 2018. See, even there is an admission by your vendor saying that they are in the possession. There is no materials to show that as per the division bench order, they have been dispossessed due course of law. Now we will hear, I will grant status quo to maintain. It's really yes.
Stating that in the event the suit is reserved against me.
No, it is
I'm giving a security that in the event.
No, let him argue. It is I have to decide. Either not Ravi argue. I have to decide that. Yes.
In the event the suit is decided in favor of my deed, I will deposit the cost of demolition. That should be the security which I will give.
Now, what is the stage of suit?
The stage of the suit.
No, now that see, if you have already started the construction, it is in that first floor and all. It is different. You are not yet entered into the land. Now, what is the difficulties? What is the difficulties if you wait for another 6 months? I will say that suit. Where is that photograph showing?
There is the other matter. If there is a bicycle way of agreement, it's a private person. Yes, that matter may be taken up. Anyway, if you want us to take up this matter on Monday, so many further arguments I can
No, I will direct them to dispose of the suit within even 3 months. You both have cooperated for early disposal. You dispose of this matter itself.
Can it be taken up on Monday?
Yes. Yes. Thursday. Yes, Thursday. Yeah, which is that matter? Is there any already order?
Both the matters about
But it was not connected. I said, yes. Use this matter along with that MFA. What is that number? 5728 of 2023. Use this matter on Thursday.
Number 48, given here for petitioner. Number 48.
Yes, 48. None appear. Leave this matter.
Number 58 adjourned, serial number 59, Vishal Shinde for appellant, Geeta Devi MP.
Yes. Yes, Mr. Hmm. Hmm. Yes. 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 Yes.
The amount actually moved from temporal. The claim is related. You know, against the equinox, the final attribute for the honorable court law. In 1997-91.
Yes. Yes.
So that investment was demanded. It is like code.
Yes.
Directly you consider the Supreme Court decision before the 2007.
Yes.
After the one law, even the written arguments were filed.
Yes.
But the court will not, without considering evidence of record.
No, what is that evidence of that? Your case is only that there is a, what is that Supreme Court said, the judgment?
Court says the law. Section 77(1)(b), that is 5 years law, that is not applicable to the proceedings under 45(a). Secondly, the law, when they claim the contribution, it must be within reasonable time. And the reasonable time will be as per the facts and circumstances. Now, as of this in the law, they have claimed the contribution after 30 years. That is related. Yes. Even the ESI contribution cannot be affected. The contribution is related.
No, what is the finding of that ESI court regarding that delay?
Then they have not stated anywhere the objection or in the evidence. They have not stated anything about the delay.
No. Why your appeal has been dismissed?
The party cannot pay. 25
Yes. Yes.
Results.
Yes.
Cannot pay it.
Yes. It is the explanation.
Offered by the respondent. After the applicant club had responded informed the applicant by letter of the but the applicant does not comply with the therefore, this point that you should see 18 of the dated 2795. It says to letter to the agency of CH-12 or hearing. The response is insurance created in the applicant plus 4 times. And finally verified the records. During verification, inspector found that and paid actual value to the expired for period of 89-95. Therefore, the report has once again issued C18-2007, giving compensation on actual basis of 8 times by state voting on the given application and after state voting, the rate of percentage was 12.70 here, it has not been changed. No. But that there is no evidence, no question of delay. They are not explained the delay by the 13 years delay in clearing the confirmation. But I have got the
Yes. Yes, that is your contention. There is a delay. Yes, let us see what she. Yes.
Because they are on 9895, 6895, 8895, 21895, and
No, that-
95.
This is a contribution for the year 89 to 1995. They have initiated in 2007.
2007.
5 plus 10 after 12 years.
There is lot of delay. There is no way they will explain. In the objection or in the evidence, they have nowhere they are stated. When they are expected in the year 1985. Thereafter from 1995 to 2007, they have kept quiet.
No, that inspection is 95, order is issued in 2007. Are there? Yes.
The order has been passed.
No, notice has been issued in the 1995 itself.
They have issued, you have filed an objection, they have not taken any action.
The respondent insurance inspector visited the applicant club for the 4th time and finally verified the records. Yes. Now, is there any obstruction and all during that inspection?
No, nothing. You have submitted the report.
Yes, let us see how she will. No, that is true.
Given to them.
Now, why that judgment said it is an reasonable time you have to be executed? What is that? Yes. But there should be a reasonable time. Reasonable time is not more than 3 years. That is what the generally said. Yes.
Is it necessary for us to keep knocking on their door constantly asking?
No, no, the question is, no, not, that is not the question. See, if you are not issued a notice in the 1995, things should have been different. Because now the question is,
Their argument now that we are very first time to be perhaps we make it valid. I don't think it's valid. Whether it's speaking, they're going far, they go with them and say, they're making it up here.
no, that is what that to exercising the power under 45A. After initiating, there should be a reasonable time. After giving in a notice, you have not passed an order for 9 years. Presumption that yes, you are satisfied. There is no deal. No, that's.
The question is now here in this case.
Yes. No, see the trial court said, you have explained the delay. What is that explained? Regarding what is reasonable time in the present case, respondent corporation has sufficiently explained the delay. Where is that explanation? Yes. Yes. You have inspected in the year 1995 for 3-4 times. Today the petitioner period January 89-95 found that petitioner wages and ends based upon the fresh report. Fresh report to 95. Note issue in 2007. You have already paid that amount.
Subject to condition, subject to
This court has passed an order.
No. There was the demand of pay.
No. Here you have paid.
Yes, I can't.
Huh?
And then because they have paid the lot, subject to that.
Before that, yes, I court you have deposited.
No, not paid. Yes,
No. Subject to which you have deposited before this court.
No. Before the yes,
No, interim order passed by this court. You have deposited that amount. Already, either this court has not passed that order, then you have voluntarily paid it. Subject to result and why you have paid? No, I thought that this interim order has been granted by this court to pay that amount subject to result. That is not. Then it's over. You have paid it.
No, I have to confirm that the amount has been paid.
No, they are saying that they have paid. You don't want to pay any further. No, further I say that they should not claim anything if it is already paid. Allah, are you sure they have paid? How confirm if it is paid, it is paid. You can't claim further. You confirm it. If it is paid, then I will confirm it. If it is not paid, then I will see your case. Yes, madam, that's all. Yes. Club but if it is paid, if it is not paid, then I will look into that merit. Paid it, then yes, yes. Yes. 20.
First time demand was 8 lakhs. They have paid, they actually compliance with it. That's not damages. They did 100. That is that. I think we can.
Let us see that now. If it is paid, they everything. Yes. When do you want? Huh? Next week. Leave this matter. When do you want? Which date you want both of them? As 5th September. 5th September. Yes, Mr. Ravi Shankar is waiting for morning. Yes.
This is what you want.
Hmm.
There is a
Hmm. Other side served unrepresented. What is the suit for? Hmm.
For appointment of guardian.
Hmm.
They are officially to sell the property.
Hmm.
When the notice has been issued, thereafter the court felt that the public will have to be given by a paper advertising.
Hmm.
The court has fixed the date on 10/4/2018. The total paper publication.
Hmm.
In the afternoon, we filed an application with our way to nine, along with the paper draft. That application.
Why?
Although no change in structural data, other
I peruse the reason set out in the memorandum of fact. Reason shown in the memorandum of fact is not satisfied in the last hearing. Order for issuance summons through the paper published by the petitioner not furnished the draft of this report. Please take to grant the matter pending for last 2 years. Now they have become major. See, now we want to sell the properties of the minor. Huh? It's a temple. Where is the client? When that order is it is this
This on the website.
10/4, I have filed by that advocate for petitioner to try to advance the above case to this date. By prior to setting aside the dismissal. When this is dismissed, Mr. On the same 10/4. But 10/4/2018.
Recall my back in producement. That application is come.
Yes. Done. This appeal is filed by appellant challenging order dated. What the order 10/4/2018 passed by Municipal District and Session Judge Dakshina Kannada on IA number 9 filed under order 9 rule 9. Right with Municipal District and Session Judge Dakshina Kannada antide 10 page number 10. Order sheet. Senior civil judge JMFC ಅಂತಿದೆ ಬಟ್ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಯಾವ ತರ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. Yes, order passed by senior civil judge JMFC Surya Dakshina Kannada, whereby application filed under order 9 rule 9 of CPC has been dismissed. The appellant herein has filed a petition under section 7 to 7, 8, 9, 10 of Guardian and Wards Act. Since the steps has not been taken, the petition itself has been dismissed on 10/4/2018. Immediately, the very same day, The application under Order 9, Rule 9 of CPC has been filed for restoration of that petition by set-asiding that dismissal order. Now you have to take everything fresh. Application has been dismissed, being agreed by the same. This appeal has been filed. The very same day, on 10/4/2018, the matter is posted for taking steps. The appellant herein has taken a draft for paper publication. There may be a delay. There is a delay in taking the steps to service notice to the respondent. However, in the interest of justice, I'm of the opinion that the appeal requires to be allowed by set-asiding order dated 10/4/2018, passed under Order 9, Rule 9, passed on IA, filed under Order 9, Rule 9. Accordingly, the appeal is allowed. Order passed by Senior Civil Judge JMFC Sulia on IA number IA filed under Order 9, Rule 9 is set aside. The IA under Order 9, Rule 9 is allowed. I will allow that application. The petition stands restored. Petition G and WC 48 of 2015 is restored. The appellant hearing is directed to appear before the trial court 20th September without any further notice. Then you take steps there.